Bună dimineața, stimați colegi, dragi invitați,
Good morning, dear colleagues, dear guests, partners. Good morning. Welcome to the third edition of the International Arbitration Conference, Smart Solutions for Dispute Resolution between Professionals. It is a pleasure to see such a diverse community, lawyers, representatives of public authorities, businesses. We are here to discuss not only rules and procedures, we will also address efficiency, trust, and trends in settling commercial disputes. I am glad to see that this conference is growing every year. If in the first edition we discussed about the need of arbitration per se, today we have a mature arbitration system. We speak about cooperation between institutions, practical experience of professionals, and the real needs of businesses. The International Commercial Arbitration Court in Chisinau under AmCham Moldova established this platform for dialogue. It is not intended only as a legal conference, but it is viewed as a space to discuss ideas in order to have a more predictable investment climate and a more competitive one for the businesses. Our conference's agenda reflects our approach. We will start by discussing the amendments to the law on arbitration. Then we will speak about the practical aspects of commercial arbitration. And then we will see which are the expectations of businesses with regards to commercial arbitration. Because arbitration is intended for professionals, for businesses. And I encourage you to see this conference not only as a mere presentation of topics, but as an opportunity to exchange ideas, because this is the real value of such events. So in the end, I would like to extend our gratitude to 𝗦𝗺𝗿𝗁, general sponsor, and our partners 𝗕𝗲𝗍𝗂 and partners 𝗕𝗵𝗁𝗍𝗂𝗄𝗏𝗂𝒑𝗡𝗏 Associații and Mixed Books Company. I would like to wish you a valuable conference and new professional connections. This is the introductory speech. Also, I would like to mention that on the screen you'll see a QR code. You can scan it in order to address questions to the moderators and panel speakers. And for those who do not speak English, because we will have presentations in English, so if you need interpretation, please take interpretation equipment so that you can listen to the translation. Thank you very much. And now it is my pleasure to give the floor to Mr. 𝗕𝗲𝗍𝗂, our conference partner. Thank you, Victor. During the Soviet times, the Secretary General used to be the most important person. So we should not forget about this, because Secretary General is also a very important position in arbitration. In my position, a partner in the lawyer's firm mentioned by Victor, and also partner of today's event, I would like to thank the other partners who helped organize this event. You can see them on the screen. I like figure number 3. It is also reflected in the logo of our office. You see this 3 angles presented, and I believe that this third edition of our conference is the most representative, and hopefully it will be useful. We would like to have practical, useful content, because we also have a kind of external background of the legal reform. And I believe this is the biggest difference of today's conference compared to the previous 2 ones, because back then the reform was only starting. But now we can say that the justice reform is a success, and this also gives opportunities for other areas as well. we can take it as a risk for arbitration, but I believe that it's not a risk. This is an opportunity, because if the situation in the judiciary is good, then the country will develop, because more investments will be attracted by the country. So it's good to have a healthy competition between courts and private arbitration solutions. The second aspect that I've mentioned, I was thinking this morning while traveling to this venue, I was thinking that it's very good that we have offline conferences, because soon we will all move online and we will just see each other on various networks. And also in the future, we can meet more often with bots, robots, to communicate with them, hopefully efficiently, but I don't know how it will happen. But I'm very glad to have this old school format, to have the possibility to see each other, to feel each other and hear each other. So now I would like to invite the first panel speakers. So, as Victor has already mentioned, during the first panel, we will address the reforms in arbitration. So Mr. 𝗕𝗵𝗶𝗿𝗀, last time he was a guest. He had an introductory speech representing the Minister of Justice. Now he is among the panel speakers. And I believe this is also a change, a good change, because as representative of the state is not only coming to congratulate us, but also will speak and will tell us about the developments. The next speaker will be 𝗕𝗶𝗶𝗿𝗀. He will present things from a different perspective. So we'd like to see what would be the fruits of this whole reform process. Mr. 𝗕𝗏, he's has a long experience in arbitration. He participated in the arbitration of the first cases, and Mrs. Natalia Iordache, judge. So it is for the first time when we had judges at the opening, and I was thinking how the cooperation would evolve between courts and arbitration. So today we have the privilege to have a representative of courts. So she will tell us from the grassroots level about the interaction between state and private institutions. So having said that, let's start the first panel discussions. So I see that this microphone is on. So I would like to welcome you from here. So let's address the topics of the first panel. So speaking about alternatives, we have to ensure the right to available alternative because we do not have a lot of time, we have to be dynamic in our discussions in order to be able to address these sophisticated and complex topics, sometimes with contrary interests. So let's start with Mr. 𝗕𝗵𝗶𝗿𝗀. You have seen the debates that we had with regards to this draft law, how to repair the mistakes made in the past, because we had two laws and professionals were asking, why did we need two laws in a single area? So I worked with our colleagues, including with 𝗕𝗏𝗂𝗁𝗂𝗁. He is with us, and I'm glad that the Minister of Justice will take it as a basis for the arbitration reform. And I remember how difficult it was in London to explain to some people why we're doing like this. So, Minister, please tell us what is happening and what is the situation. Mr. Gladey, esteemed audience, dear panel speakers, on behalf of 𝗤𝗏𝗏𝗁𝗏, Minister of Justice, I would like to thank you for the invitation to participate in this conference dedicated to arbitration, the third edition, as Mr. Ghălădăi has mentioned. This is an essential area for the functioning of a modern judiciary and for development of a competitive institutional system. Speaking from this perspective of the Minister of Justice, I would like to believe that this year's conference has a separate meaning. It is taking place during an important period of the arbitration system when the regulatory framework is being consolidating. On the 16th of February this year, the Minister of Justice started the procedure of expressing the legal opinion together with a number of authorities and professional associations, as well as in public consultation. So we are working on the legal opinion on the draft law on arbitration. The draft law was developed with a group consisting of practitioners, lawyers, business representatives. So I'd like to thank them for their contribution and for their dedication. As Mr. Ghălădăi has mentioned, we did not start from zero. You know about the study that was conducted previously in 2021, and also there was another draft law back then, and we analyzed it. We took it as a basis. The draft law development process during the working group started in late 2024 and had the goal to establish a modern regulatory framework, a coherent one, aligned to the international standards, able to ensure stability, predictability, and efficiency. I would like to highlight some of the main directions of the changes planned. First of all, this project has a monist concept in arbitration compared with the dualist approach, because you know that in Moldova there are two laws on arbitration, number 23 and number 24 of 2008. So the idea is to unify these provisions into a single legislative document to be applied to both types of arbitration. This solution would strengthen the legal framework, would ensure a more coherent enforcement of the law. Second, the draft transposes fully the provisions of the model law of the International Commercial Law Commission of United Nations on international commercial arbitration. This alignment is of significant importance in order to align the national system to the international best practices and in order to strengthen, to increase the trust of external partners in Moldova's business environment and in Moldova as a country. This model law was used by the working group, and any deviation from that model law was analyzed in details. Number three, the draft law intends to increase the attractiveness of arbitration as an alternative dispute settlement mechanism. A first element in this regard is the new arbitration regime. This draft introduces a new presumption of arbitration for patrimonial disputes and non-patrimonial disputes, to the extent that parties could conclude a transaction within the meaning of the Civil Procedure Code. The exclusions are clearly defined. Credit agreements for consumers, guarantees related to them, including collateral agreements, and three, family law disputes. Moreover, the draft stipulates expressly that a dispute cannot be settled through arbitration only if it is expressly stipulated as an exception in the law. I would like to tell you that such a provision was included in the draft, and I hope this will not happen. But if the constitutionality of this provision is challenged in the constitutional law, I'm not sure about the outcome, but we have arguments to support the constitutionality of this provision. Another essential element is the detailed regulation of the preliminary conclusions pronounced by the arbitration court. These mechanisms are intended to protect the integrity of the arbitration mechanism until the final decision is pronounced. Conservation of evidence, maintenance of the status quo, and ensuring the effectiveness of the decision to be pronounced. This regulation will provide efficient procedural tools to the arbitration tribunal in order to upgrade the draft. It introduces the possibility to use remote communication technologies. So if a certain party is not present, the arbitration tribunal could decide for the hearing to take place using video conference equipment, telephone, or other communication means. This solution reflects the developments and realities in international trade, and this will enhance the flexibility of the arbitration. Last but not least, one of the main innovations is about the enforcement of the arbitration decision in the national legal system. The draft stipulates the executory nature of the arbitration decision. So if the arbitration decision is not challenged within 30 days, it becomes executory automatically. We will not need the preliminary procedure of a court to issue an executory title. So we believe that this solution will enhance the legal power of an arbitration decision. It is important to highlight that the new regulatory framework on arbitration should also be analyzed in the context of the European path of the Republic of Moldova. The commitment to approve an arbitration law is included in Moldova's roadmap, and it should be passed by the summer of 2026. At the same time, we are aware that some legal amendments to other laws and regulations should be made in order to align, and we believe that until March 1st, 2027, this will be done using the working group. So we believe that harnessing the dedication of the working group members will manage to adjust the other laws and regulations to the provisions of the new arbitration law, and hopefully all of them will enter into force on the same date. I would like to say that this draft is of high interest for our colleagues from Brussels. So once we finish the legal opinion, it will be submitted to our colleagues to get their view on it. We are aware that the success of a new legal framework does not depend only on the quality of the provisions. It is also very important to have an appropriate enforcement mechanism. That's why the consultation process is very important. So we kindly invite professionals from various areas to participate in the consultation so that we have a solid, sound, and strong legal framework. The draft can be found on the website of the State Chancellery, Minister of Justice, as well as on 𝗕𝗲𝗁𝗔𝗿𝗂𝗏𝗏 platform. I'm sure that through joint efforts, we'll manage to strengthen and consolidate the arbitration system as an efficient system that can be used to settle disputes. Thank you very much. Thank you, Mr. 𝗕𝗵𝗶𝗿𝗀𝗀. I would like to reiterate Victor's recommendation to use the QR in order to write your questions or comments. So please, if you have a comment or a question, scan the QR on the screen and send them to us. So yes, indeed, if we remember the National Harmonization Plan and the annexes to it by the end of 2026 and the others by the end of 2027, so this is a huge package of laws that have to be approved, and I'm sure that the Parliament will be very busy with adopting many laws, and it's important to make sure that the public consultation part is done appropriately. And I also would like to highlight that a working group is not established for all draft laws because it's not compulsory according to the law, but a public consultation is mandatory by law because it's important to hear out all of the opinions. I do not participate in the working group, but we as an institution are well represented. I am monitoring these processes, and I believe that the communication, the mutual hearing process is very fluid, and I believe that this is a guarantee that the final outcome will meet our expectations. But let's see how it comes out. And now let's move to Mr. 𝗵𝗍𝗍, who will also speak about legislative process. Thank you very much, Mr. Hlaďej. Good morning to everyone. I would like to thank organizers of this conference for their invitation. This is a good opportunity to participate in an interesting discussion, a discussion focusing on a very important issue, a topical issue. Now we have the new draft law on arbitration, which is now subjected to public consultations. And now it's the best time to exchange opinions so that we can find out what is the opinion of businesses, civil society, what are the issues in the arbitration system, whether the new draft law will manage to address the problems. Why a modern, efficient, and coherent legislative framework on arbitration is needed? Because the quality of arbitration decision is a crucial factor to promote and ensure the efficient operation of arbitration as an alternative dispute solution mechanism, as a form of private justice. Some people are afraid when they hear these words, private justice, but these are not scary words. In the international case law, including the case law of the European Court for Human Rights, arbitration is recognized on the basis of Article 6, access to justice, as an independent body established according to the law, which has the goal to manage the act of justice. The quality of arbitration law is important also from the perspective of attracting foreign investors, business people, because arbitration and the place where it takes place is very important. That's why the arbitration law is important in terms of whether disputes can be subjected to arbitration, because it's very important to understand clearly which disputes can be settled through arbitration and which cannot. That's why at the level of principles, in the arbitration system of a certain countries are very important. And of course, the enforcement of arbitration decisions, including the foreign ones, are important as well. There is a tough competition between the countries to increase the attractiveness of the arbitration system in their state for cases of international arbitration. What is the situation? What can we say about our legislation? So we do have some history in this regard. The first law was approved in 1994, the law on judgment by elected arbitration. It was a transition law because the country was in a transition to market economy. But of course, it was not aligned to the needs, and in 2008 a new legal framework was established, law number 23 on arbitration and law number 24 on commercial arbitration. Why two laws were needed? Frankly speaking, I have never understood, because I participated in the working group, which worked on law number 28. So two working groups were established back then, which worked independently. They did not cooperate during the development of those drafts. The draft laws were submitted to the parliament, and the parliament approved them. And during the implementation of these laws, we found out that it was not a good idea to have two separate laws, because there were some gaps, some contradictions between these two laws. The terminology used was different, the definitions were different, so it was not clear how these two laws correlated. Their scope was not clear as well. There are two opinions. One opinion says that law number 23 on arbitration is the framework law, which includes general rules that can be applied for international arbitration as well. And law number 24 is a special law specific to international arbitration, and rules set out in law number 23 are applicable for the scope of law 24. There is another opinion. Law number 23 is used only for internal arbitration, and law number 24 is used only for international arbitration. And we have this confusion also because in law number 23, there is a reference made to international arbitration, saying that disputes with foreign elements shall be subjected to international commercial arbitration. But the next paragraph of the same article in the law says that the establishment and operation of international commercial arbitration is regulated by law number 24. So the fact that there are two laws is not a new thing. As the State Secretary has mentioned, yes, indeed, there are such approaches in the international practice. The 𝗧𝗔 system with only one law and the 𝗔𝗿𝗯𝗶𝗁 system with two separate laws. And I have to say that there are some developed countries that use the 𝗧𝗔 system, for example, UK, Netherlands, Sweden, Germany. On the other hand, there are countries that have a developed arbitration system like USA, France, Italy, which use the dualist system. So it does not really matter which system is used by a country. It is important how these laws are implemented.
So a working group was created, which decided that the best solution would be to align to the mono system, to the single system, and to take the unilateral model law. But we have to acknowledge that law number 24, it is indeed based on 𝗬𝗓𝗓 model, but not law number 23. Hence, it was decided for this in principle to have one single law, which would be based on the 𝗬𝗓𝗓 1985 law with amendments from 2006 concerning international arbitration. Why? Because this is a good law. Moreover, we have followed the recommendations, the guidance given to the member states, UN. So in a resolution of the General Assembly, states are recommended to take into consideration this law when developing their national legislation in arbitration. Moreover, they were recommended to follow as much as possible the letter of the international law, because this was meant to ensure a harmonization of the legislation at the global level, and it would strengthen the trust of the foreign participants in international trade, because this law is addressed to them concerning the trust that they have in the legislation of the respective state. So from the innovations that were added to the new bill, I wouldn't want to repeat what the State Secretary has already mentioned, which in a very short but very ample presentation has already underlined the key novelty of this law. I would like just to focus on one particular aspect, mentioning the execution of the arbitration decisions. So we'll see how the discussions will evolve further, naming that in the arbitral decision award, it will have an ipso facto immediate enforcement execution title, so there will not be necessary to issue a confirmation and for the issuing of a writ of execution, which would increase or strengthen the attractiveness of arbitration, and it will make more efficient the implementation of the legal act in the different commercial disputes. Concerning the next steps to be taken, the State Secretary has mentioned that the review of the norms will follow, of the connected normative framework will follow, so the procedural code, civil code, and the execution code, and in particular, this aspect is the most important. So the most important things actually is to come yet, because the new law is a good law. However, we have to align also the connected framework, because we have some discrepancies identified between the provisions of the law that has entered into force, law number 24, and the civil code procedures. And I will give you one single example concerning the motivation for the elimination of the writ of execution, and the terms are also different. They use annulment in one, and respectively, the motivation is very different, because the argument is very different, that does not exist in the civil code. So the incapacity of the person to sign the decision, and in the civil code, there are some arguments that are not existing in the arbitration law. So a very important discrepancy also is linked to the annulment argument based on contradicting with public order, or in the law they are using the term public order, and in the civil code procedure the term of principles, general principles of the legislation of the Republic of Moldova, and the moral principles, or fundamental principles and moral principles. Are these notions identical or not? So if we would analyze more in depth these notions, these terms, we are reaching the conclusion that they are similar, but they are not identical. So we have to make sure that we harmonize them and to use uniform terminology. What is absolutely necessary to be added in the connected legislation, and in particular in the civil code procedure, is the interaction between the courts and the arbitration courts, which means the control of the arbitral awards. It is absolutely necessary for the Moldovan courts to align to the international standards concerning international commercial arbitration by adopting a limitative interpretation of the notion of public order, in order to avoid that pretending that public order is being violated, the courts to censor the way that the court has solved the dispute, because unfortunately, presently this occurs. And I believe that my colleagues will voice out, will provide details about such cases. And actually, this is a recommendation of the Supreme Court of Justice, a decision of 2015, decision number 2, which states that the courts have to annul an award only when it goes against the fundamental and moral principles, and not censor the way that the Court of First Instance are examining, the way in which the Court of First Instance are deciding on how arbitration is dealing with the arbitral awards. So they shouldn't evaluate the evidence and appreciate the different procedural norms, because an arbitral award can be annulled only based on formal reasoning, be it when the arbitration agreement is not valid or efficient, or when the right to defense is being infringed. To conclude, if you were expecting some critics to this bill, then I will not engage in such criticism, because I believe that this is a good bill. Why? Because it used the model law of the Commission of UN for International Trade. Yes, we still have to work on it and still develop further the connected legislation, and as a result we hope that we will have an efficient, modern legal framework which will make our country more attractive for our national businessmen, but also more attractive for the investors and our development partners. Thank you very much. Thank you very much, Mr. 𝗵𝗫𝗁. We have 2 questions addressed to you. We could address them now or later together with Mr. Țărinca. We have a technical one, but let's focus on the questions that are addressing particular subjects. If there is like a dilemma, for example, let's start with the simple one. If the apostille will be maintained. So you can open the website that Mr. Sabrenko mentioned, and you can find this answers to these very technical questions that you have. And the second one is indeed a very interesting one, which has created a dilemma, and respectively, if the labor disputes are arbitration, and what could be changed in order to make them fall under arbitration. Actually, there was an attempt always, and also to include their non-selection for arbitration, because there was a lack of symmetry. This is my own perception as a practitioner, as a lawyer for many years, and I don't think that only in Moldova. I believe that our Romanian colleagues could share how are things in their own country, but I believe that there was judiciary solidarity is always with the weaker part. So with the employee got always the positive decision, but I believe that it's not the place for a social contract to be adjusted. So Mr. 𝗧𝗵𝗶, I don't know if they could fall under arbitration, so they could fall under arbitration, work relations, but please let us know your opinion. Yes, this is our opinion as well. The exception of those disputes that are not arbitrable, I mentioned them according to the law, but the ones related to labor, the perspective of the working group working on the bill, I believe that this could be included indeed under the disputes that could fall under arbitration. So this is the short answer to the question. So the practical implications, unfortunately, I do not know them. I do not have experience with them, and our colleagues, lawyers that are working with such disputes, maybe they could share with us more about how they are being solved in an arbitration procedure. Yes, I had this type of arbitration, and I believe that once there is this practice created, that the courts are supporting the employee rather than the employer. That's why it's not really beneficial to reach such situations. So a priori, so where does this character come? Supportive character for the employee comes. So if you were fired, so you, for example, I had a dispute with a CEO, so a leader of a financial institution, and you can imagine the salary for 1 year salary, it was very high. So the temptation of sharing, I don't know if it's the right term to use it now, it's also very high. So this temptation in arbitration, because that's where we're starting, the independent character of arbitration. So respectively, since it's not an employee, an arbitrator, so it's about the perception of the business. And in panel number 3 is the question of Mr. Timov, the one that raised the question. So what is the main obstacle here locally? So under panel number 3, we will talk about the perception of the business. So let's move this question for that panel, because it's a very, very good question. And I believe that our colleagues from panel number 3, I would like to invite you to shed more light from your own perspective, if there are any obstacles, or how did you manage to overcome these obstacles, because more and more we can see you turn to arbitration. So to what extent businesses are involved in the process of consultations of the legal amendment? So you have mentioned, according to Law 100, we are talking about the public consultations. Yes, as mentioned, all those interested could provide comments to this bill. So there was a deadline. So the term was February 16th plus 10 days. At least this is the term provided to professional associations and local public authorities, but it would be best if you could meet this deadline in order to move forward quickly and address the comments and proposals. So you mean No, starting with the 16th, so plus 10 days. So yes, 26 is today, Festina Lente. So yes, today is the deadline, if you wish. I don't believe that you will not accept comments coming after the deadline. Yes, you are quite right. We will not deny them, but if you are more diligent and you could mobilize yourselves and support our suggestions, our proposals, then and submit your proposals, then we will definitely look into them. I don't know who has raised this question, but I believe that directly the business sector was involved. So AmCham, as a professional association, we had this perspective. So we have shared the voice or the opinion of the business sector. So it was not a theoretical legal battle, but it focused on the practical side. So namely the enforcement character of arbitral awards. This is an important issue because it has several facets, and the countries that have or had the courage, they took on a great responsibility as well, because in order to equal a state and a private arbitration, this means that not all jurisdictions are actually ready to take on the enforcement character to be acknowledged without requiring this filtration through the state institutions. In our study, we have identified the following finding, that this is a radical measure. If this solution was identified and decided, that means that there's a radical response, but I believe that it's a synonym to robust in this case. So it's not a negative thing. In order to see what happens, and if you will allow me, then I would like to invite directly Mrs. 𝗕𝗏𝗂𝗁, and then I will let you talk about the ecosystem, because I like this holistic approach, and Mrs. 𝗕𝗏𝗁 will talk to us, will present about the relationship between the judicial system and supporting and strengthening commercial arbitration. So I am a judge at the Chisinau District Court. My name is Natalia 𝗕𝗏𝗁, so I'm working in the suitability panel, but today I am present here to talk about a very important subject for us all, which is the role of the judicial system in supporting and strengthening commercial arbitration. So representing the judicial system, I would like to convey a clear and honest message in the name of the judicial system, and namely that the courts are supporting you and are a friend, or are friends of the arbitration. Moreover, based on the activity of a judge and of the court hearings, we are actually encouraging for certain disputes that the legal framework allows for alternative instances, courts to have them addressed, to be sent to arbitration. So we would have also beneficiaries that would be more happy about the quickness of the process, and we would also be more thankful for reducing our workload of assessing all the cases submitted to us. But how is this friendly attitude manifested? So arbitration cannot work independently. It does not work in an ecosystem, but rather arbitration requires support, the support of the courts, and it requires its support when they are examining three areas, namely the recognition and the enforcement of arbitral awards and the issuing of the arbitration writs, and also the issuing of enforcement orders. So in exerting these competences, this attribution, arbitration would be vulnerable without it, and it wouldn't have the expected outcome. What is important when providing this support? So two aspects are very important. So first of all is for the courts to observe, to respect the independence of the parties. So when they have decided, the parties decided for the disputes to be resolved by arbitration, to observe, to respect this decision, and not to put under question the will, and to not exert an excessive control but to provide a respectful attitude towards the decision of the client, of the beneficiary. So the second important thing concerning the support provided by the courts to the arbitration institutions for when these competences are exerted by, as mentioned, the recognition, the challenging, the issuing, to focus only on the reasonings of the law, as the procedural civil code procedure has regulated what infringement of procedures and what fundamental values should the court look into. The court should not verify if the arbitration instances, the institutions have indeed assessed the evidence properly, or the circumstances of the case were identified. In such cases, the court transforms into the second level of jurisdiction, and the parties have selected or chosen the arbitration in order to avoid this two-tier jurisdiction, and we have to respect their decision and to follow strictly the letter of the law. So before this presentation, I have checked the statistics. Maybe you can help me. So I have looked at the statistics as of 2021, and I have checked the number of files received by the courts, which have the object, the recognition of the arbitral award and their execution, the issuing, respectively, of the writ of execution and issuing of the enforcement order. So you can see here the statistics. We have files returned and resolved 48 and rejected only 9 as of 2024, received 73 after they were being solved. So 48, only 6 were returned. In 2023, we had 71 received, solved 55, and rejected 12. In 2022, we have received 81 and examined 70 and rejected in the end only 14. As far as I see, as of 2021, we had a higher number of such requests of the funds received. I do not know the reason for that, but I see that is the year with the highest number of such requests focusing on this subject. So I looked at the Chisinau District Court, looking at all the received files to see if indeed the judges have focused only on the competencies foreseen by the law, and they did not exceed their level of control. And you see here the final examples here that they have used either the lack of arbitration clause. So the next slide, please. The lack of an arbitration clause, the case number, you can see it here. So the court has identified that the arbitration clause is missing, and thus they have rejected the issuance of the writ of execution by arguing that it was a transportation case, a contract, and this contract was signed only by one of the parties. So the arbitration clause was not signed and it was missing. So the courts have limited their control to procedural aspects as the civil procedures foreseen it. In another case, this also had as an object. So regarding the annulment of the arbitral award, so the court stated that they are violating the fundamental principles and that there were international sanctions applied, and it was concluded that these sanctions applied to the statutory administrator were violating fundamental principles, and the court made a difference between the physical person and the statutory person to which were international sanctions applied. But these are very different subjects with different responsibilities, and even if the physical person had the statutory role, statutory administration role for the legal person, these sanctions are not automatically being reflected on the legal person. So, based on the cases that I looked into from the Chisinau District Court for 2025, is that the judges are ready and that they are applying a limited control based on the procedures foreseen by the Civil Code. They didn't go over, and if they would go into the essence of the case and reinterpret the norm, then this would be a different tiered level of the jurisdiction, and they would then express their opinion on the case itself. Besides the support provided by the courts concerning the request of recognizing the arbitral awards and the issuing of the writs, so other competences were issued, which I believe that the courts have a more active role, as for example, applying protective measures or applying provisional measures or appointing the arbitrators when there is a deadlock identified in that process. By exerting these competences, I would say that the court is not only providing support, but a partner of arbitration institutions, even if in practice lately I did not see such requests coming in. I believe that the judges are ready to face such requests, such cases. Moreover, we have a decision that is guiding us in that direction, and I believe that the judges will take the right decision if receiving such requests, such cases. Ending my presentation, I believe I would like to convey the message that this is not a preference to have this friendly attitude, but it's a respect towards the decision of the two parties that have chosen to use this type of resolution for their disputes. It means disciplining the judiciary system and following strictly the letter of the law. As a court, a balanced court is a court that knows its own competences, and it intervenes only based on the legal provisions and the competences that it has. The law allows us presently to have a balance between arbitration and the courts. Moreover, arbitration is being developed not only through laws, but also through a constant and predictable practice. And I believe that we, the judges, we are ready to provide a fair practice, a balanced and predictable one. And once again, I would like to reiterate that courts provide support to you, and I encourage you to trust the message that I'm conveying. However, if there are specific cases, as I've heard today from other colleagues, maybe older cases from 2022 or other periods of time, we are all different. We see things differently, and maybe there are some exceptions to the case. However, these could be discussed through the judiciary practice. They could be solved through seminars, through the CSJ, Supreme Court of Justice, that we hope that will reinstate its activity based on these recent issues that are creating dispute. So this is the message I wanted to convey in the name of the courts, and I do hope that we were sufficiently clear. I'm very, very happy to hear this narrative and this very positive attitude, and I honestly believe that it's very positive one, because we are often complaining, but we should look at our own issues, and the experience of 𝗕𝗲𝗂𝗶𝗿𝗀, our colleagues, which had the first arbitration experiences, could tell you. You have the arbitration clause already on the website, and you can copy paste it, and you don't have to reinvent the clause when an arbitrator could then wonder what exactly is included in this clause. Let's do our homework, and then when we are going to the court, we will have then the right to criticize, because statistics, actually, the statistical figures didn't look very optimistic, because it looks very different. So it's 9 out of 71, so acknowledged and issued the writs, but all the other 9 that were assessed as being rejected, and if they were rejected, yes. Well, I would like to mention here as well that these are decisions of external foreign, so this is not only from the national level, so this is the total number of rejected cases. That's why it seems so. Yes, but we do our own assessment, and Victor, probably it would be best to do it in 2026. We did it last in 2022 based on the data that Victor assesses from the courts and from the perception of our own members, and our statistics were also optimistic. Where usually the issuing of the writ of execution is not being rejected, but I've heard that this happens only when there is only an objecting reasoning for that, and this should be the tendency. And indeed, when there are exceptions, I'm thinking of what Mrs. Iordache mentioned, and if there are any exceptions, let's put them into discussion, because in my course at the National Institutes of Justice, I provide different case studies, and I'm using actually a few emojis with a smile or a sad face. So if you think that it's a sad case, then you can add the emoji. It's not about the sadness that you feel and that you're solving with your psychologist, but if we're talking about the national level and about some issues that are being created, and the vetting actually showed that these decisions are actually not wrong, because they are an outcome of misunderstanding some of the legal norms. And that's what I believe that it's important that we have the courts. 9 years ago, when we initiated arbitration, we had here in the room judges present as well, and I looked at how they were looking at me, and I noticed maybe this attitude that they were not trusting us. And I remember that our colleague from the German arbitration court, and she was telling us that most procurement disputes are going to the private institutions, and judges are not solving too many of such cases, and there is some sufferance there. And you remember, maybe when we've initiated the vetting process, you might remember how the prosecutors were going to the finance experts, and they were learning about the financial law, because our education institutions are not teaching them that, so they were paying financial experts to teach them on financial law, to deal with the social contract cases. Thank you very much. There are 2 questions, but I believe that they are addressed to you, Ion. So you shouldn't necessarily address or answer these questions before your presentation. But the first question is a broader one. How do you believe that the popularization or promotion of arbitration among public authorities should take place indeed, because the state authorities are usually staying away from arbitration. But now, since we had or have a department, we educated a department, so this question is a very good one. So how public authorities, so not the courts, but public authorities, Mr. Kozvan, if you have a richer experience in this field, please jump in, and anyone here in the room who has more experience, please share your input. If we look at the social contract perspective that I really like, because we all assess the social contract, and public authorities are on the front line, and it's very easy to have this jealousy or rejection attitude, and otherwise it's how to address, how to digest this product, and how to transform it into a nutritional element, if you wish. So please go ahead.
And another question for you. The contract has an arbitration clause. The debtor is insolvable. Does the creditor can submit a request for arbitration? Dear participants, traditionally, we are used that if something does not work well in the society, we have to amend the law. So now we will approve a new law soon. That's the third stage already. The first one was in 1994 when the law on arbitration courts was passed. Then in 2008, other two laws were passed. And now we have the third stage, the third challenge. So and now we have to wonder whether by adopting a new law or by amending the existing legislation, will it be enough to revitalize the arbitration system in the Republic of Moldova? The first answer would be yes, but I believe the correct answer is no, because the law alone is not enough to make a change in the arbitration area. So I would like to tell you that arbitration is an ecosystem consisting of several components. Yes, of course, law is the main component because the law is the one providing the vitality for arbitration. But in addition to law, we have other important components, such as the arbitration institutions that have to be well organized, or arbitrators that have to be correct and professional, or businesses that should use arbitration, or the legal culture that needs to exist in the society, in particular among lawyers. And if all of these components work efficiently, arbitration will work as well. If one of these components is not very efficient, then this will impact the whole arbitration ecosystem. Regarding the law, yes, the law is good. The provisions in the new law are not new. The previous laws, number 23 and 24, in particular, law number 24, were based on the INCITRAL model law. So there is nothing new. We cannot say that new provisions appear that did not exist before, but approval of this new law would be the first step only. But it has to be followed by other very important steps where the legislative reform needs to continue. I'm speaking about the intervention of courts. The arbitration courts can be well organized, the arbitrators can be well prepared, well trained and honest, but if the interventions is arbitrary, then it will affect the whole ecosystem. I like to hear the presentation of the judge that the intervention of, or that the judges express their will not to intervene abusively in the arbitral awards. But unfortunately, the court practice reveals some animosities. In 2020, or until 2020 or 2021, I was member of the Supreme Council of Magistracy, and then I was challenged to have a cooperation between the arbitration court of Chamber of Commerce and Industry and courts, because on the National Courts portal we could not find all of the arbitral awards and decisions that were pronounced. So between the Chamber of Commerce and Industry, respectively the arbitration court of the chamber and the court administration agency, a cooperation agreement was concluded. This cooperation agreement can be found on the website of the Chamber of Commerce and Industry. So that cooperation agreement committed the court administration agency to publish all of the decisions and awards that are pronounced with regards to termination requests. The statistics that was presented on the screen features all of the cases in courts that are related to arbitration. But I believe that is there something wrong with the microphone? So we have a problem. We can see the requests that were approved and rejected. So we should not think that the statistics are alarming. In the judiciary practice, in my judiciary practice, I've seen two cases as that should not exist in the judiciary practice. Myself, as an arbitrator, I'm always interested every time when I see something new in the judiciary practice, especially when an arbitral award is terminated, to see what were the reasons for me to avoid them, or in order not to commit an abuse. So there is a decision dated 2022. It's an arbitral decision. In the first instance court refused the termination, and the Court of Appeals terminated that arbitral award. So if we read it, we'll see as an example of how not to do by the courts. For example, that's a huge error committed by the court. That's an alarming case, a case that should not be ever present in the judiciary practice. Another situation is about, well, this will be eliminated by the new law, but we have a request to terminate an arbitral award or a request to issue the executory title. So the first decision that was issued by the Chisinau International Court of Commercial Arbitration, the arbitral award was not terminated. It is still in force. The creditor went to the court, asked for the issuance of the executory title. The court, both at the first instance and the second level, so both courts decided that if the founder and the administrating manager is notified, then that is not notified. This is a ground not to issue the executory title. So we have the following situation. The arbitral award is in force, but the creditor did not receive an executory title. So the creditor cannot go to court because an arbitral award was issued, and the creditor cannot start enforcement actions because he does not have an executory title. In the judiciary practice, and actually I would like to speak about another element of the ecosystem, arbitration institutions. So we can see that we have 35 arbitration institutions registered. I don't know if at least 5 of them are functional, are operational. Most of them do not operate at all. I've seen in practice a decision issued by, I would say, a pocket arbitration institution. The arbitrator interfered in the area of insolvability, because I would like to say that the insolvability court has the exclusive competence to review insolvency cases. But in that specific case, the arbitration institution issued insurance measures asking so it declared, it nullified contract resolution notification, and with the same decision it obliged the cadastre department not to make any changes in the register. So these are some issues that were took upon by the arbitration institution in violation of the express legal provision, which said that arbitration does not have any competences in this area. So we have a question: if such situations occur frequently in our practice, but I believe that we have many professionals or many situations can be sent to arbitration institutions, and I'm not afraid to call them pocket arbitration institutions, because these are institutions that are established for a very narrow specific situation intended to create burdens and difficulties. So if this happens, then the whole arbitration ecosystem will be affected. Regarding the question that you asked with regards to the fact whether there is an insolvency procedure and if parties should follow the arbitral clause or not, currently the insolvency law stipulates clearly that when an insolvency procedure is started, all of the cases, all of the requests are within the exclusive remit of the insolvency court. So, as I've said, if insolvency procedure starts, any arbitration decisions or awards become inoperable. So if an insolvency case is started, the arbitration case is suspended, and the creditor should obtain a collection decision as part of the arbitration stipulated by the arbitral clause, and then to go to validate the claims. So there are solutions. It depends on the will of the lawmaker. Regarding the popularity of arbitration or spreading, popularizing arbitration in business community. Unfortunately, I would like to say that the legal culture is not yet well developed. That's why arbitral clauses in contracts are not often included. Oftentimes, as a lawyer, I talk to other peer lawyers, and there are many complaints that civil cases are being tergiversated. Sometimes they last more than half a year. And I ask them, why don't you go for arbitration? Because you don't have to wait for such a long period of time. You'll get more quicker. You'll get quicker decision. And Then people ask me, what should we do to be able to use arbitration? And I said, the answer is simple. You have to include the arbitral provision in your agreements, in your contracts. And what will happen next? You'll go to the arbitration institution. But how this happens? So this discussion shows that these things that we believe that are very easy to understand, unfortunately, lawyers are somehow afraid or reluctant to include arbitral provisions in contracts and to use arbitration. In order not to take a lot of your time, I would like to make a conclusion by saying that arbitration will flourish. Arbitration will produce tangible results only when all of ecosystem components are functional. We have good quality laws. We have arbitration institutions that are well structured and well organized. We'll have arbitrators who are professional and honest. We have businesses that use arbitral clauses and include them in contracts. And when we have enough and a good legal culture to promote arbitration. Thank you. Thank you very much, Ion. First of all, I would like to thank organizers and congratulate them for this event. I see so many young people ready to become arbitrators. I've never seen so many people wanting to be arbitrators, but I'd like to say a couple of words. Arbitration started in Moldova in 1994. The Chamber of Commerce and Industry declared that it wanted an arbitration court back in 1993, but the law was not in place back then. So 35 years have passed, or even more than 35. We have a law approved in 1994, a kind of pilot law. We have other two laws in 2008, and a third law is being prepared now, but we do not have any arbitration. There is no arbitration. That's why I welcome such events. And I believe that you will become the messengers of arbitration that will disseminate the idea of arbitration as an alternative dispute settlement mechanism. I do not want to speak about the draft law, which is declared to be good, but it's not. We have been always wondering, let's identify the existing gaps, the existing laws. When we interpret a legal norm in a way, when you go to the court and the judge has another interpretation and terminates the arbitration decision. So we have been trying to find an answer to this question for 20 years already. So unless these problems are solved, the law does not matter. The two laws are okay. If France has two laws, are we more Catholic than the Pope of Rome? Yes, that's an ambition of someone. That's why I will not address this topic, because I have my separate opinion. I will present it in writing. I have a question to the Secretary General, because most of the disputes, not only in the Republic of Moldova, but in the whole Europe, are reviewed by the permanent arbitration institution, not by ad hoc arbitration, because that's why we have to focus on those institutions. They need to be regulated somehow in the law. So, esteemed Secretary General, when a permanent arbitration institution is set up, we have to communicate with the Supreme Court of Justice. We have been discussing about this for dozens of years, the Minister of Justice needs to register these institutions. I see that the new draft law stipulates that this will happen. We have 38 permanent arbitration institutions. That's the Supreme Court of Justice is telling us. But could you please tell us what are they doing? Because we have only 3, 4, or maximum 6 institutions that are actually operating. What are the rest doing? If you read the communications of the Supreme Court of Justice, you can see two arbitration institutions with the same registered address, with the same phone number. So why do we have such a situation? We need to have order in this area. So that's my question. And in addition to this question, I have 2 recommendations. First, the Minister of Justice, together with the Minister of Economy, need to work intensively to promote arbitration. So we say that France is the most advanced in arbitration. It is regarded as a pro-arbitration state. The state is promoting arbitration. French science said that it's not enough to pass a law, you have to promote it. So you have to promote arbitration. And the second recommendation, this used to be done in early 2000. The Minister of Justice used to promote intensively arbitration. Many workshops, conferences were organized with the participation of arbitrators, judges, different projects. But in the past 10 years, no such events take place, or at least I was not invited to them. So this is very important. It's important to have a good interaction between arbitrators and judges. Republic of Moldova is a small country. The Chamber of Commerce and Industry is the only institution promoting arbitration. We work with businesses and we try to tap into any opportunity. So we present advantages of arbitration, the strengths of arbitration. But it's enough to have one arbitration decision dismantled, terminated by a court. All of our efforts are in vain. So it's very important for courts to have some standards. And we need to know these standards, to follow them. And judges also need to take into account the peculiarities of arbitration. So we have to work together. And if we do so, arbitration will develop. And we have to work and focus not only on promotion, so that each business and each individual knows, but we also have to work in depth, so that we know all of the peculiarities, all of the specific aspects. Because, you know, the law is imperfect, because it's at the general level. When in UK, the Lord's Chamber, a complaint against an arbitration award was sent, and when they read the decision, Lords started to clap for the well-structured sentences in that document, because this is an art, this is a skill. So we need to have a good law, but we have to be creators to create good decisions. Before answering, I don't know if you remember, in 2008, when myself personally, we had an arbitration case in Kiev. Mr. Postovan was an arbitrator representing Moldova. So he is a legend of the Moldovan arbitration. Regarding the question how the Minister of Justice should regulate, I believe that the best regulation is the regulation by the market. I do not think that the state has to interfere too much by exercising too much control. Because again, this is a private justice. People will go to professionals. and here we need actually judiciary control to avoid the so-called pocket arbitration. If you remember the well-known situation when a decision had to be enforced, nobody wanted to do it, and they managed to do it in 𝗕𝗀𝗃. So that's not arbitration. This is a way when somebody did it in order to achieve their narrow interest. So, Mr. 𝗕𝗵𝗶𝗿𝗀𝗄, please, if you'd like to respond. Thank you very much, Mr. Postovan, for the recommendations made. We had some discussions with him when we set up the working groups. We invited him in the working group. His recommendations are precious. We highly appreciate them. But you know, the Ministry of Justice and the mandate of the Ministry of Justice as a public authority is not to interfere, not to damage things. Our objective is to have a regulatory framework within the mandate of the Minister of Justice and to make sure that this legislative framework is smooth, does not create any barriers. And the professional associations need to adopt their own arbitration rules. We, the state, do not want to interfere too much. This is a private initiative. We need to make sure that there is a regulatory framework in place, and on the basis of this regulatory framework, for arbitration institutions to approve their own procedural rules. And it's very important for these rules set up by the law to be the same and to be aligned to the rules used by other countries, so that a foreign investor knows that the Republic of Moldova passed the UNCITRAL model law. So I have some predictability what would happen in Moldova if I would have the need to settle a potential dispute. So this is our vision. Yes, there are states where they have two laws, but sometimes I go to the Constitution, to the Supreme Court. I know the case law, and we have a principle used by them, a prohibition of parallel approaches in the law. So it's not okay to have two laws, especially that we have laws that have some contradictions, as Mr. 𝗵𝗍𝗍 said. So that was the purpose, to have a clear legal framework, a clear law, which can be understood, a law based on some rules that are applied by other countries as well, so that Moldova becomes attractive economically. But I agree with the statements of Mr. Postovan. Yes, we have to disseminate and to popularize arbitration. It's necessary to organize more events of this type. So such events are a great opportunity, a great platform to disseminate information about arbitration. We are very glad that you have reached the third edition. We are thinking maybe we could plan an event at the Ministry of Justice, but again, we do not want to interfere too much with the private initiative, because arbitration is a private initiative. Thank you very much. I am sure that the next meeting will take place at the Ministry of Justice. If you remember, a couple of years ago, we had a meeting. Mr. Ieșanu was the Secretary General. And I believe that we have to institutionalize the communication with the Minister of Justice, to meet in the conference room of the Minister of Justice to discuss all of the issues and questions. And I would like to make a statement regarding the duration. That's a question that makes a difference. So how much time elapses between submitting the arbitration request and receiving the executory title. So I would like to refer to the fast-track procedure that it is institutionalized according to the arbitration rules of the Chisinau International Court of Commercial Arbitration, and I believe other arbitration institutions use it. So for this fast-track procedure, the court sets up a maximum period, and how we plan our work to achieve it, it's our problem. We can work overnight, during weekends, but the decision is issued by the set deadline. So it's 6 months maximum for the fast-track procedure. It can be done quicker, Ioan says. I remember yesterday. Okay, so the arbitration procedure is quicker. So our kind request is give us a chance. And I believe that the colleagues speaking in the last panel will give us more details. Elena, the first to bring us litigations, to bring us disputes in arbitration, can confirm this. On this positive note, I would like to end the first panel. I hope that we've managed to set a positive and optimistic note for the following panels as well. Thank you very much.
Doar o mică precizare, noi nu vom face pauză între panelul 1 și 2. Și vă rog, dacă aveți
There will be
nevoie
no break between panel 1 and 2. If you need water, you can find it in the back. In just a few moments, we will continue with the second panel concerning the practical experience in the international arbitration in the trade sector, and just a few technical moments, and then we will move forward to the second panel.
Bună ziua tuturor! Scuzați de aceste momente
Good
tehnice.
day, everyone. I'm sorry, it's about cabling. So I'm ready. My name is 𝗬𝗏𝗏𝗏. I'm the head of the legal department at 𝗫𝗏, and we are partners, the general sponsors of today's event, and we are happy to be part of this event for the business and the legal communities. And we are happy to be able to support such initiatives of AmCham and of all the others that are suggesting the organization of events that bring together specialists and the business sector. In today's panel, we have subjects focusing on practice linked to commercial arbitration and investment arbitration. These are linked to energy, constructions, and the use of AI, one of the last presentations, and a retrospective, an overview of what to expect before, what to expect within the EU and in the EU integration process, and what will change with the EU instance of arbitration. So I would like to give the floor to the panelists. So we have Sorin Dolea. He practiced arbitration in Geneva, Frankfurt am Main, Vienna, and he was involved in international and commercial arbitration processes following different types of rules. He is also a rapporteur in commercial arbitration, and he is also a sub-member of the Greener Europe, and he will have a presentation on the green energy and energy arbitration. So I'd like to thank the organizers for this conference and for giving us the opportunity to speak about some key issues in international arbitration. I will address today some of the aspects linked to energy arbitration, and I will focus on three aspects, respectively on the energy commercial arbitration in 2026 and moving forward. Secondly, green transition arbitration. Green transition is a very broad concept, and I will focus on carbon certificates, the discussions, and last but not least, about the future of the Energy Charter Treaty and if the Energy Charter Treaty has any future. Concerning commercial arbitration, so I've recently noticed an attempt to the contract concerning the supply of energy from in a direct conflict with a clause included in the contract model regulated, which is approved by the ANRE, the regulator, National Energy Regulatory Agency. And this conflict can be solved and is solved based on some articles from international law. So we are talking about the New York Convention, Geneva, concerning international arbitration. Moldova is a signatory party in both New York and Geneva conventions that are stating the following, that the arbitral convention or its validity is determined according to the law applicable to the convention, but if the parties has not expressly stated them, then it will be determined to the law applicable to arbitration. Therefore, at least at the theoretical level, if the parties include arbitral conventions which is governed by a foreign law, not Moldovan one, or the place of the arbitration will take place outside of the Republic of Moldova, then it means that this convention will be valid even if its validity will be doubted in the Republic of Moldova, regardless of the law applied in the general contract. So this is unanimously, generally respected principle that the special one special laws are separated from the general contract. So in 2026, we will continue seeing disputes concerning natural gas, and they are very different, and I will not stop here for too long. But the question is, what does the Republic of Moldova to do with the international disputes with the traders, transportation? And the answer is that in this case, in the future, because they have many assets in the Republic of Moldova, we might see many debtors and creditors of the decisions of the arbitral awards to try to find or to try to solve these disputes. One of the recent ones is Naftogaz against Gazprom, when Naftogaz have earned an award of 1.3 million US. So we'll see what the tendency will be. So the second category of arbitration are linked to the green transition. Starting with 2018, once the Paris Agreement was signed, entered into force in 2018 in Moldova, so the so-called carbon markets were created. The carbon markets represent a platform where the pollutants and the large companies from the industry, they are compensated their emissions by acquiring certificates from the operators of ecological projects, and they are investing respectively into projects that are capturing the gas. So we have regulated markets. One, the well-known, is in the EU emissions trading system, but we also see independent companies that are voluntarily buying these carbon certificates. And take into consideration that we do not have the practice, but also the lack of regulations. So arbitral disputes or general disputes, they are arising from different types of transactions, the real quantity of emissions and the extent to which a certain quota were calculated or not. Moreover, we do see that many associations, emissions-related associations, and the decarbonization, include in their contract models the arbitration agreements. For example, the International Commission Trading Association, the most renowned in this sector, they are suggesting for them to submit the request to the International Arbitration Court, which recently has adopted optional rules which are applied specifically to the environment. So this is a very current issue in the world, and I believe that in a few years it will be also in the Republic of Moldova. The last but not least, I would like to refer to the future of the Energy Charter. This is a multilateral treaty. The Republic of Moldova is signatory to it since 1998. In 2024, it was modernized, and the member states have implemented certain amendments which are focusing on the new technologies, decarbonified technologies, and certain terms concerning expropriation, the fair treatment in order to be adjusted to the new realities, the realities of 2024. That being said, the treaty continues to include fundamental standards to protect the foreign investment. Two of them is respectively the fair treatment, and the host country has to apply such a treatment, which is applying a fair and equitable treatment to all the members of the treaty, and also it shouldn't expropriate illegally, because we know that in international law, expropriation could be also legal in the national and international law as it is foreseen by each state. I would also like to point out to the fact that anytime scheme of support, and I've mentioned it in 2023 at the previous conference as well, and probably I will mention it during this next, if Moldova will still be a member of this treaty. So the support schemes are representing a merit for the creation of legitimate expectations. If the state is promising something to foreign investors, then the state needs to hold its promise throughout the established period. And modifying the rules of the game during an ongoing game led to frustration concerning arbitration procedures linked to investments. 2025, the Ministry of Energy has submitted to consultations a bill concerning denouncing the treaty energy charter. They've also submitted an information note, and they invoked that the EU members are denouncing it without explaining too many and without explaining the reasons for doing so. I would like to mention that this treaty has also a survival clause called the sunset clause, which foresees for the investments which were realized before the date will be protected for another 20 years. Thus, let's imagine that in 6 months the country will denounce this treaty. It does not mean that the investments that were already achieved, and we do have investors in the energy sector because the energy sector is dominated by foreign investors, it does not mean that they will not be protected. They will be protected for the next 20 years. This being said, thank you very much, and I am very happy to address any questions. Thank you very much, Sorin. I have a question before questions come in from the room. So we are talking about the legitimate expectations of the investors and a fair treatment towards them. On the other side, the state has a vision to incentivize green energy and to amend the legal framework and to modify its perspective on how to produce energy in this entire chain, and then the EU factor as well. So I wanted to ask, what is the limit between the legitimate expectations of the investor and the right of the state to modify its policies, including the energy and environment sector? We're talking also about human rights here. You should know that at any court which is assessing the level to which the expectations were not observed, so this is a fundamental question that is being solved by each separate case. Usually the arbitration courts take into consideration, first of all, the goal, the objective of these amendments, the merit for these amendments that have affected the foreign investment. And these amendments, they have to observe a certain legitimate objective purpose of the country. But at the same time, they should not occur in an abrupt way in order to change in a substantial manner the regulatory framework applicable to investments. There is a lot to discuss about the limitations, but I would actually state that there is no clearly defined limitation, both in the doctrine and in the investment arbitration law, case law, because it's a very diverse one, which is the most important actually standard in the investment law. But on this other side, the states have also the right to come up with measures. Yes, it's true, we do not freeze this. Yes, this is the main attribute of a sovereign state, to regulate the social interactions, rapports on its territory. The fact that they have entered an investment relation, it does not mean that it has to freeze the regulatory framework. At the same time, it has to create a predictable regulatory framework. But at the same time, the investment climate could change somehow important is to not apply a radical or non-transparent discriminatory measure. So, for example, an indirect expropriation, hidden expropriation through certain hidden measures. So I believe that this would be the limit, but I believe that there is a lot to go into here. So non-discriminatory measures, expropriation, so these are separate standards in each treaty, and indeed the one measure of state could include several infringements of the respective standards. Thank you very much. And should there be any additional questions, then I will read them out as we move forward. And I would like to invite now Mr. Horia Dragic. He's not a partner. He is a partner of 𝗕𝗲𝗶𝗶𝗁 Bucharest in the dispute resolution, and he has a very broad experience in arbitration and resolution of disputes. So you are invited to continue the subject because it's truly linked to what Sorin presented earlier. So thank you very much for your invitation. While preparing for this panel, I really was pleased to see that when I thought about today's topic, that Sorin also has addressed the same subject at the end of his presentation concerning the future of the Treaty Energy Charter, and this indeed a very difficult issue. And concerning your question of earlier, where the state should stop, Romania has already gathered some experience in this regard. Back in 2005, 2006, thinking about the development of green energy investments. They have added in the legislation a support scheme by providing green certificates to the producers, to the energy producers from renewable sources, and for each megawatt of energy that they produced, they were allowed to receive a certain number of certificates having certain values. Romania and Spain became a certain El Dorado territory concerning green energy investments. Unfortunately, the 2008 economic crisis hit us all, and the Romanian state understood that they do not have sufficient resources to support the entire support scheme. Hence, they have dramatically diminished the number of the green certificates issued and the period of time for which was covered by them. And that's when the question was raised where the state should stop front of the legitimate expectations of an investor. Of course, their expectations were that this support scheme were to last 20 more years and they would have a return on investment. But however, when the context has changed, the investment landscape, then this investment was not efficient anymore, and this led to quite a few investment disputes. I would focus maybe here on what was mentioned by Mr. 𝗵𝗍𝗁 from the previous panel. He mentioned that private justice practice should not be a scarecrow, and it was not a scarecrow. For a long time, the EU and the EU member states were the champions of promoting the bilateral treaties for the protection of investments. If I recall, I believe the first one was signed by Germany back in 1959, and a fundamental development of the landscape of arbitration for investments. So 𝗥𝗲𝗄 International Convention concerning resolving any type of dispute linked to investment, signed by over 150 states and ratified by Romania as well, and signed and ratified in 1992 and ratified in 2011, if I recall, by Moldova as well. And so the dispute between an investor and a host country to be resolved through this mechanism of investment arbitration. The source of competence of the arbitration tribunals resides either in the exit convention or bilateral treaty for the investment protection, or the contracts, direct contracts signed between the investors and the host country, and also resides in the national laws concerning the protection of foreign investment, at least in Romania, in its law concerning the protection of a foreign investment, foresees these alternative mechanisms leading to exceed arbitration even. From what I saw, and please excuse me if I'm wrong, but Moldovan legislation also allows the arbitration of these disputes between the investors and the host country, but it's not very precise because it does not refer to a forum, but rather is a general provision. The parties are free to convene to decide on a clause, on an arbitration clause, and a forum which would allow the arbitration of such disputes. It seems that the EU was scared at some point by this private type of justice. Here on slide, you see an error about the bilateral. It was signed respectively on the 5th of May 2020, not 2000. This is an error on the slide. So this fear has kicked off by the 𝗕𝗵𝗶𝗿𝗱 case decision, where an arbitration award between the investor and Slovakia was arbitrated in Germany and reached the European Court of Justice with some preliminary questions concerning the compatibility of the international investment arbitration with the EU legislation. And by a very surprising decision at that time, because the EU was an advocate of this type of treaties, EU itself being a signatory of the Energy Charter Treaty, so not only the member states. So it was clear that this modality of resolving disputes was supported by the EU. And in only 3 paragraphs of this award in the 𝗕𝗵𝗶𝗿𝗱 case was destroyed basically an entire basis of the arbitration between the EU member states. So what did the European Justice Court state? So basically that these compromise clauses were not compatible with the EU law because the tribunals, investment tribunals, were not a part of the judiciary system of the EU, and at the same time, as the means are limited to control the legality of such arbitral awards, an inconsistent application of the EU law could occur, and as the EU court is the guardian of the application of treaties, implementation of treaties, with a very hard hit, has decided that such type of arbitration could not take place. But of course, there was a pushback, a very firm, strong response of the practitioners, coming from the practitioners from the investment arbitration sector, and the largest majority of the arbitration tribunals have refused to apply the argumentation from the 𝗕𝗵𝗶𝗿𝗱 case and continue to consider itself competent to engage in the resolution of these disputes. As far as I know, only one single arbitration tribunal has decided that they do not have the necessary competencies, but there was a particularity in that case because the headquarters of the arbitration was in Sweden. Following this 𝗕𝗲𝗂 decision, the EU signed an agreement concerning the termination of signing the agreement. So in May 2020, the agreement was signed on the termination of bilateral investment treaties, and the last amendment was in 2022, made in 2022. Only 4 countries did not sign this agreement: Austria, Ireland. However, Ireland previously had engaged in denouncing these treaties, and these countries opted for unilaterally denouncing these treaties or through bilateral acts. And the European Court of Justice took a step further in the case 𝗕𝗏𝗏𝗏 versus Moldova. In that case, it was a case between an investor from Ukraine and the host country. Both countries were non-EU member states, and the 𝗔𝗍 found in this case a modality to extend its competencies by showing that when there is an interpretation problem of the EU law or a coherence relates aspects concerning the consistency of applying the EU law, then the arbitrability of such disputes cannot be accepted. The problems generated by these decisions of the 𝗔𝗍 are evident. On one side, all the EU member states, following these decisions, have refused the forced execution after the 𝗕𝗲𝗂 case. So even if the arbitration tribunals have decided that they have the necessary competences, but basically they had nothing to work on in the EU countries. So after the EU, all the other countries have accepted the forced execution, and we are talking here, of course, about the assets of the host countries that are not falling under the jurisdiction of the national jurisdiction. Of course, the richer countries have more assets, and the less richer countries less assets. Therefore, Romania finds itself in a better situation from this perspective. So very interesting is also the saga of the Nicolae case against Romania. And my colleagues from Nestov, they have actually worked on this case for over 20 years. This arbitration lasts for 20 years, so it's extraordinary for the lawyers involved in this case. What's important to remember from this, to take away, it's clear that foreign investments are important in the Republic of Moldova. The statistics that I've studied, that I looked into, half of the foreign investments are from EU member countries, which raises the question concerning the protection that these investors might have after the EU integration will take place. According to the current schedule, Moldova should be integrated sometime in 2029. Until then, a solution should be found to allow these investors to find or to get the protection through other solutions. After the 𝗕𝗲𝗂 decision, a romantic safeguarding solution of these bilateral treaties was identified. Practitioners thinking that probably some protocols or additional acts will be signed, additional acts to these treaties, in order to extend their validity, or at least to clarify their validity. However, after signing the European Treaty of denouncing this bilateral treaties, this is an obsolete solution in itself. So we should rethink thus the corporate structure of investments so that an investor of a non-EU nationality to exist in order to benefit from the protection provided by these bilateral treaties. And in the end of my presentation, as Sorin did talk about the sunset clauses, type of sunset clauses, which would allow traditionally extending the protection of the treaty once the treaty is terminated. So between 5 and 20 years, it's a case-by-case solution. And EU had a drastic decision here as well, saying that these sunset clauses will terminate immediately once the treaties are terminated, which means that investors cannot use this clause, this protection clause, which theoretically would have been ensured by the treaties. And it is quite interesting, and according to the Vienna Convention on the treaties, the states can convene on terminating the bilateral investment treaty at any time. However, these treaties are developed in order to create rights for tertiary parties, investors. So what happens to the third parties that have had a protection throughout the validity of the treaty, and in addition, through the clause that allows the protection between 5 and 20 years, and all of a sudden, this third party finds itself left without any type of protection in this regard. So this represents an issue which is looking for new solutions. A new or even two cases are ongoing in Romania. So an insurance against Romania. So the problems rose after the bilateral treaty was terminated, and let's see what those arbitration tribunals will decide. Thank you very much. Keep thinking about your own clients. Maybe it's important to change the structure of the investment and to find a state that still has a valid treaty into force. Thank you very much. The Nicula case continues to be a case discussed during the different implications of this case, stating that anything that could happen actually in an arbitration case happened here. They have actually mentioned about the lack of jurisdiction in Romania. We have adopted a law before the European Treaty, and they have renounced to the bilateral investment treaties, although the decision was favorable one, no type of assets on the territory of Republic of Moldova can be considered. Any type of payment by the state is considered state aid, and it's infringing other provisions of the integration treaty, etc. And moreover, you also mentioned that the EU has took a step further, and actually it went further than you mentioned, and third countries as Canada, for example, that usually, well, in theory, have a non-impacted bilateral investment treaty, non-impacted by the ECJ and the EU and all the other acts, have signed treaties with the EU concerning the suspending the bilateral investment treaty, and in the end they have signed a new investment treaty with the EU. So this reorganization of the structure that was mentioned by you earlier is something far away in the future, and it should be very carefully assessed and evaluated by the investors when they are looking into what jurisdiction that they should choose. So in the countries that are presently following the integration and the members.
Ultimul stat care a semnat un tratat bilateral cu Moldova.
Scuze, la noi era Sorina ultima vorbitoare.
I'm sorry, Sorina was listed as the last speaker, but we have the presentation. No, I'm okay to be the last one. Okay, thank you very much, 𝗕𝗲𝗄𝗧. It was a very interesting presentation. I am thinking what would be Moldova's future once it becomes an EU member, what would happen with our regulatory framework. So I believe that we'll have to think about it. We'll have to analyze intra-EU, as I understand, this is not applicable anymore. But if Moldova is an EU member state and we have somebody outside of EU, we'll have the sunset clause that protects investment and we'll have to apply it. In theory, protection could exist until Moldova joins EU. After that, it's a question. This is applicable for Romania as well. Moldova did not annul the provision in the law on foreign investments that still offers to international tribunals competencies to settle these disputes. So, at the level of EU, we have committed not to apply these treaties, but at the national level, we still have a law that is in force that confirms the possibility to have such disputes arbitrated. So it will be discussed during this arbitration case, Uriens against Romania. So we are still waiting in the energy sector to see what would be the solution, because for sure in that case we will discuss these matters as well. Thank you very much. And now I would like to invite 𝗕𝗲𝗂𝗂𝗂𝗁. He will speak, he will present the particularities of arbitration in constructions. Over the past 15 years, he was involved in many cases of arbitration in construction. He was an arbitrator and also a chief arbitrator. Thank you very much, Aelita. With your permission, I will stand. We were discussing with Victor from AmCham about what to address in my presentation, because arbitration in construction is a very broad topic, but this topic is very much anchored in reality, and it relates to very tangible things, concrete, steel, infrastructure that we can see in our everyday life, all of the buildings around us, the roads that we have to travel. And initially, I wanted to make my presentation a bit more technical, but after that, I've decided to focus on a narrow topic, the arbitration in construction and contracts in construction. I will speak about FIDIC contracts, but I have never seen any contracts in constructions that would not have a forfeiture deadline. I remember about 15 years ago, I was contracted by some contractors from Romania. The applicable law, material law for this contract was the law of the Republic of Moldova, and some matters were raised with regards to forfeiture deadlines. So the first question that I asked myself, not my colleagues from Romania, because my colleagues from Romania only sent an email to me. So the first question was, what is a forfeiture deadline? Because our civil code back then did not have any express provisions about the nature of forfeiture deadlines, how they operate. The situation changed in 2019 because we have a chapter consisting of 3 or 4 articles that explain what forfeiture deadline is and how it can be implemented. Well, the old civil code did not have these direct provisions, but nevertheless, there were elements or examples of these forfeiture deadlines, 1 year time related. So I had a colleague that graduated from the Iași University, and she understood the difference between limitation period and forfeiture deadline, and I had some discussions with her for about 2 days, and I understood the difference between these 2 terms. In constructions contracts, forfeiture terms have a very important role in the dispute resolution process. So I will speak about the forfeiture deadlines when the contractor has some claims, and also when the employer or the beneficiary has some claims. I will use the 𝗕𝗏𝗁𝗏 model from 2010. It is an association of a French association of some engineers who developed model contracts. They can be used in different countries by different industries that have connections with engineering structures. Moldova is using these contracts when foreign funding is used for design or for constructions. Let's discuss a specific provision. I encourage you to analyze this provision, to read it. We can read it quickly for you to understand the meaning of this provision. So, if we analyze this provision, we can notice several things. If it refers only to contractors' claims. By the way, in the 2017 version of 𝗕𝗏𝗁𝗏, which is similar to the one you have in front of you, but in the 2017 version, this clause was changed and both parties were included, both contractor and employer. This subclause 20.1 is applied in 2 specific cases. If you have a claim that is about extending the the completion period, and 2, if you have claims related to additional payment. So usually they exist. So only in these cases, the contractor is obliged to send a notification to the engineer. So here the most interesting part starts. This notification has to be sent within a period not longer than 28 days since the contractor became aware of the violence. And if the contractor does not send the notification within 28 days, the completion period will not be extended, no additional payments will be approved, and the employer, the beneficiary, will be relieved of any liability, will be released. So the contractor loses the right if it failed to send the notification within 28 days. So, representing employers, beneficiaries, we've seen that contractors, when they failed to send the notification within 28 days. So they would say that this time period of 28 days goes into violation with the limitation period of 3 years. And we have a specific provision, Article 409 in the Civil Code, which says that the forfeiture deadline cannot affect or fraud the limitation period. But we said that we have to differentiate these two concepts. That's number one. Number two, we would bring some examples from abroad where the UK courts are using similar provisions from FIDIC contracts and other types of contracts, said that it's not a problem. 28 days is enough of a period for large contractors. Normally they are big companies, so they can meet these deadlines. The French approach is that this period is okay, but we have to analyze the specific circumstances. And when we analyze the FIDIC provisions and the real case practice, the idea is that within 24 days, you just have to send a generic notification. You do not have the obligation to have a clear, quantified, and well-justified claim. Because if such a request was introduced, then the situation would have been totally different. But it's not the case. It's enough just to send a notification, to entitle this notification possible delays related to, I don't know, the August rains or September rains that could generate some additional costs. Whether you are entitled to these additional costs or not, that's a second question. But the idea is that if you prepare such a letter consisting of 3 lines, then you'll not lose your right to send later a well-justified claim according to the procedural steps. The same subclause has another provision which says that within 42 days since this problem occurred, or since the contractor should have become aware of this problem, some details or specific details of the claims should be provided. But this 42-day period does not entail any consequences. So then it's a question, is it a forfeiture deadline or not? So people said that if the contract stipulates that this is a forfeiture deadline, then the same language should be used by other parties when coming with the arguments that this is a forfeiture deadline. But here we do not have this termination, so it means that this is not a forfeiture deadline. But then we have a question, so what kind of deadline, what kind of timeline is it? So why should we have such a provision which can be ignored? But the practice is uniform. It says that you cannot ignore these deadlines, this time bar, but failure to comply with it would be a non-essential failure to implement the contract. So this is a non-essential violation of the contract. So you've complied it, it's good. If you did not, it happens. If this failure to comply with the contract caused damage, then you have the right to ask to have these damages repaired. But you need to have evidence. So you have the right to submit a claim, but you cannot submit the evidence later. But in my practice, everyone submits the evidence later, and very seldomly people say that no, you cannot submit now the evidence because 42 days have elapsed. No, it does not happen in reality. Most of the time, these 42 days are seen as a time period which, if you do not comply with it, you commit a non-essential violation. Another approach in the same contract is clause 2.5, which refers to employers' claims. So we can see that it's much broader than 22.1. So the contractor, so here the provision is much more detailed for employers. So the employer, in any situation when they have a claim to the contractor, should base it on 2.5. And an official notification should be sent to the engineer. In this case, the engineer is a third party, but paragraph 2 of this clause is very interesting. It says that, yes, you have to send it as soon as practicable, but not later than 28 days. It's the same time period as in 20.1, so not later than 28 days. And let's see the consequences. So the employer will have the right, will be entitled to make claims against the contractor only in accordance with this subclause. So we have the question, what this consequence is about. Is it a classical forfeiture or not? If yes, why parties or the author of this type of contract used a different language compared to 20.1. If you wanted to make it exactly as 20.1, then you have to introduce the same consequences using the same language. But if you have a different consequence, it means that you do not expect the same consequence. Then it is not a forfeiture deadline, but it's a forfeiture deadline, but you are just using different words to explain it. Well, it's a bit weird. And here there are different directions of interpretation. Marian Nicolae, Romanian professor, wrote a monography on the limitation period in FIDIC, and he also addresses forfeiture deadline. And he says when we read 2.5, this is a forfeiture deadline, exactly like 20.1, full stop, no more questions. That's one approach. Another approach, I don't know whether I've seen it very often. So they say that 2.5 is not a forfeiture deadline because if it were, then it would have used the same language as 20.1, and it would just have written that the contractor does not reply or does not have any liability towards the employer. And in 2016, in the English Technologies and Constructions Tribunal, this is a classical tribunal where the awards, the decisions of this tribunal are very well justified in the constructions area, and many cases are reviewed by that tribunal. So in 2016, Murphy and Sons case against Better Energy says, when we read 2.5, so that's not an exact quotation, but it says the following. When we read 2.5, it would have been a forfeiture deadline if the object clause that we would like to apply, for example, something related to a criminal clause or some delay penalties. So if the object clause that we would like to apply makes a reference to subclause 2.5, meaning that 2.5 is not implemented independently. It's a gateway provision. So 2.5 is applied only if another provision makes an express referral to 2.5. But if a certain provision does not refer to 2.5, then 2.5 is not applied. So this is a kind of conditional forfeiture deadline, if you want to put it like this. That's quite an interesting approach. And I would say that it's somewhere in the middle, like Solomon's wisdom. I don't know whether I agree or disagree with this. It does not really matter for our discussion. But if we use this logic, 20.1 is also sometimes referred to by other contracts exactly in the same fashion as 2.5, whereas by other clauses do not refer to it. So I do not know whether we can apply these logics. At the same time, 20.1 has a clear consequence, whereas 2.5, this is the consequence. If it's clear or not clear for you, I don't know. For Maria Nicolae, it's very clear, but for the English court and some other scientists, they said, I don't know, we do not see this automatically as a 𝗕𝗏 deadline. So then we have a question of contractual balance between the contractor and employer, when the contractor would always have a 𝗕𝗏 deadline if it goes through 20.1, and the employer does not always have a 𝗕𝗏 deadline because it goes through 2.5. So 2.5 is applied only if other contractual provisions refer to 2.5. So that's all I wanted to tell you. Thank you. Thank you, Sergey. I believe will be different depending on the side you represent, if you're a judge or an arbitrator. I did not want to present my opinion because everything that I've presented are opinions of others. But when I am an arbitrator, I will listen to the arguments of lawyers and parties. It's a very interesting opinion. We had some good, interesting cases in constructions. So before arbitration, we have the engineer with problems or another judge. And if this whole procedure does not happen and a party goes directly to arbitration, what should an arbitral tribunal do? Declare itself competent? So that's the first question, whether the arbitral tribunal can declare itself competent to settle this dispute. The second question, the party that feels that is losing the process is appointing one arbitrator, the other party is appointing the another arbitrator. The supra arbitrator should be a professional in road constructions. For example, he or she should know exactly the technology and so on. But arbitrators are lawyers, they are not engineers. So we had some discussions. We said, we'll find a professional, a specialist. The tribunal can appoint it. No, we want that subject matter specialist to be the supra arbitrator, because we felt that he is very influent and could go to the court, and the court could say that the arbitration tribunal was not established according to the will of the parties. What should we do? So regarding the first question, there are two different approaches. The first approach is that we have the will of parties expressed in the contract, and if there are some pre-arbitration steps that have to be taken, then you cannot go to arbitration unless you go first through those steps. On the other hand, and that would be an issue of jurisdiction. On the other hand, this issue can be qualified as an issue of admissibility in a case where I am participating. I cannot give you a lot of details, but this question was raised and the tribunal decided that it can suspend the proceeding until the other party goes through those steps. So the other party came with some arguments why it failed to go through the pre-arbitration steps. So that was an issue of admissibility, not an issue of jurisdiction. So the tribunal has the jurisdiction, but offers 3, 6, or 8 months to the parties to go through the pre-arbitration steps. And after that, if still needed, to go to arbitration. Regarding the second question, parties' will, in theory, should be compulsory when setting up the arbitral tribunal. But at the same time, we have to take into account some pragmatic issues, whether we have such professionals in place or not. So as far as I remember, super arbitrator should be taken from the list of the court. And unless there is such technical specialist in road construction, I don't see an issue for this super arbitrator not to comply with these requirements, because these requirements cannot be fulfilled objectively. So what's the purpose then? What's the purpose of the party's will if this will cannot be fulfilled? But what would be the reaction of the court? It's very difficult to answer to this question.
Absolut.
So take into account the fact that judges could have a different interpretation. So we have lots of such cases. That's my point. I thought that that's what we will discuss. The interaction between arbitrators and judges. This has to be taken into account. Thank you. I would like to reply from the perspective of the Romanian law, or the practice of the arbitration court under the Romanian Chamber of Commerce and Industry. So regarding the first question, yes, I agree with the two perspectives presented earlier by Andrei. So there are a number of hypotheses. There is a hypothesis when this doubt procedure, which is like a preliminary procedure, is eliminated by the parties. So authorities have understood that a pre-arbitration procedure takes longer time and costs more compared to the situation when you go directly to arbitration. Of course, Article 20.6 has a different interpretation, but if parties have not given up on the pre-arbitration procedure, myself as an arbitrator has to check whether the parties have acted in good or in bad faith, because you know that they need to act in good faith. For example, the party that acts in bad faith cannot be released from its liability. And this cannot lead to inadmissibility. So the solution presented by the arbitration community is to sanction the abuse of right committed by the parties acting in bad faith. Regarding the second question, I support Sergei's opinion. I believe that a court and an arbitration tribunal, when analyzing the jurisdiction according to fit and competence rules, it has to follow the arbitral convention, and I will address this in my presentation. So when the dispute occurred, they need to find some common ground between parties, but this is very difficult, if not impossible. So when determining the autonomy of will and what is happening in reality is the arbitral convention that is agreed and signed by the parties when each of the parties wants to cooperate with the other. A cooperation that as a rule does not exist when the dispute is in place.
de ani de arbitraj. Cred că știu ce vă întreb.
26 years in arbitration. I know exactly what I'm saying. So the question is, if there are some standards, how much should we follow the whims of the parties? So the question is if there are any standards that we have to take into consideration and that maybe should be reflected in the future law. Thank you. So another question. I would like to add as a practitioner in the FIDIC type of contract. So the FIDIC type of contracts, these are a very complex type of contracts. So they depend on those standards mentioned from 2010, 2017, and depend on the rule and the directive of each donor, of each financing part. So these are the FIDIC type of projects adjusted by World Bank. There are FIDIC contracts adjusted by UNOPS, so other type of contracts. So it's very important in this case to answer your question. So usually the FIDIC contract, they force you to pass the dispute resolution board, and it's a mandatory aspect. And then I wanted to make a recommendation. Yes, we have a legal, I don't know if we have representatives from the public authorities as well. So when you are doing savings, when you're saving money, when you are signing contracts, this is actually a disadvantage leading to losses of millions of US dollars, because any businessman and entrepreneur, as you've mentioned, Mr. Koval, is a professional. And oftentimes when we started the implementation of some major projects, some entrepreneurs were saying lawyers first, with different claims. And we suggested back then, when you have an infrastructure major project, you have to have a strong professional engineers team and implementation team that could explain that the interest is not submit as many claims as possible, but to develop a construction project, and that you are able to counteract it. If the implementation unit is weak, then this will fail, because the FIDIC contracts have so many terms and you have to follow the deadlines, and if you don't meet them, then the consequences are really severe, really bad. So we went over time a bit, but now we have Sorina Olaru. She is a litigation lawyer, partner Nestor Romanian, a member of the board of the International Arbitration Court affiliated to the Romanian Chamber of Commerce, and is involved in the amendment of the new rules of the court. So she has experience in many courts in Romania and in arbitration. She will speak to us today about AI in arbitration. Thank you very much, because initially my presentation was created in English, but also I'm sorry for going over time, but I will speak into Romanian. So the title of the presentation is Adjudication Reimagined AI is a Smart Solution for Dispute Resolution. So I've appreciated the fact that it is really a current issue to address the new era in resolving arbitration disputes, taking into consideration the fact that AI is already present, even if we refuse or not to acknowledge it. But it's present in our lives and in the processes that various legal consultants, lawyers, and arbiters are taking into consideration to solve the arbitration issues. So the issues that I wanted to address are the following. The state of AI in arbitration today, so what AI can and cannot do, what are the key legal risks or fundamental risks, and who sets the rules, and if there are any disclosure obligations, and what are the sanctions, who can apply them, and in the end, a few recommendations to allow you as of tomorrow to refer to the control of use of AI, regardless of our role as lawyers or arbitrators in such a dispute situation. I will, in particular, focus on slides 3, 4, and 5, because I believe that they reflect the fundamental issues that we should take into consideration. So first of all, what is the state of AI use in arbitration today? Between 2015 and 2022, the use of AI in legal procedures meant mainly one thing, what Americans or Englishmen say, e-discovery. So it's a phase in which technology was used to assist the review of documents or to identify documents. So at that stage, it was confirmed and recognized as usable, especially by the international level, because it was used that level by the courts from USA and UK. So this represented a phase of uses certain AI modules accepted and verified and confirmed by the court. Thus, we are not in a situation which would lead to some risk linked to arbitration. However, as it says in more technical language, it was under the radar. It was not popularized as an element of AI use between 2021 and 2023. In particular, we used AI instruments and tools for legal research, and you have them listed here on the screen: LexisNexis, Westlaw, etc. However, all of these tools, they are more safe compared to what happened in the next phase, 2024-2025, when there was an inflection point as a new form of AI appeared, the generative AI, which means generative AI means that it creates content. You give them some documents, you feed it, and it can extract reports, quantum analysis. It can create, develop arguments and documents because it can interpret the information based on some algorithm. This type of AI was embraced quickly by the users. And we've conducted an experiment. Actually, I was telling my colleagues earlier this morning, an experiment with the students from one of the law departments from Romania. Maybe I shouldn't say which one. When during a competition of simulated cases, so 40 have used, all of them, AI in order to solve a case that they had worked on and to prepare their memos. So it's used either, regardless if we use it, agree with it, acknowledge it or not, and all the other bots, Gemini, Plot, and Legora, the newest on the market, or Harvey, are used for AI, and we will see, starting with 2025, that we'll have a new form, agentic AI. These will be the bots modules that are using AI that go beyond the phase of identifying data from databases and restructuring them, but they themselves can engage in autonomous sequencing activities. So what we autonomously think and do, we believe that the AI could be reacting in the same way. So this agentic AI, it's quite dangerous if we talk about it in the context of arbitration. What could you do? So I didn't come here today to scare you regarding the use of AI, because AI is here. It's not going anywhere. The goal is not to use it. The goal is to learn to use it in a way that would allow us to control it and lead to real outcomes. So the example that I've shared, you see it here, it's an experiment conducted by an American professor. There were 120 law students participating. They had 6 tasks, so they were put in 2 groups. Some worked with AI, others without. So one group with AI, another one with it, because this was the format of the experiment. So these are the findings. Those that have used AI have drafted faster. Their answers were better structured, and they had stronger legal analysis. So 3 out of those tasks presented a stronger legal analysis. And for the routine tasks, cumva, they have shared things, and the AI was underperformed on very simple detail-related things. This shows that we could use it. What for? First of all, when we are reviewing documents. Generally speaking, all of these AI modules, they work based on an algorithm, which, and probabilistic principle, which reinterprets what already was written. Based on those algorithms, we could reach the conclusion that a text that AI receives to review could restructure the information, and that information could be rewritten in a very quicker timeline or fast, but to obtain a more precise formulation. Broadly, it is used in arbitration, in particular for translation and the transcripts of hearings. But imagine construction arbitration with parties representing different jurisdictions which do not use the same language for communication. So imagine a tribunal with a 3 arbitrators panel, arbitrators that do not speak the language of the parties present in the arbitration. I wouldn't want to go into investment though. And all of these should be generated and inserted in a transcript, which the arbitrators could easily read, assess, and could take a decision in the respective dispute with all the fact and law-related issues. So it is used also for the timeline analysis. So we are referring here to those red pathways used usually by our colleagues from construction arbitration. You know that there are many events which could be on the critical pathway of a project and which could generate time and jobs, by the way, related to those 28 days that you've mentioned. So if parties have a system, or the businessman or the authority has an AI that is documenting data, they could establish the delay, and how could this delay affect the total time and the costs of the project. Surely these AI platforms, modules, they could be used or can be used to extract data from databases. LexisNexis are referring to, but associated, of course, with verification. So data which are verified, and any errors are verified, and citations have less risks of errors. And it is used presently for case prediction. So it has already a rate of success of over 75% on case prediction. This is not present in Romania yet. So we have two types of litigations. We don't talk about arbitration disputes because it's difficult from different perspectives. So access to information, confidentiality, the particularities of the cases. But let's say if we have different type of claims for execution, and the rate of success developed by the professors of this specialty in Romania have reached already 75%. Imagine you receive a very complicated case, you are feeding it into an AI module, and it tells you that you have 20% or 30% or I don't know how many percentage to win the case, and 75% of these cases give a similar solution. How important is that for a party to take a decision to adapt its cost and time linked to this arbitration dispute? Of course, it can be used, but of course, there are some risks. And now I will turn to the risks. So first of these risks is the hallucination and fake citations. So that's how it's called in the system in 2025. So this is the best known. So it's not the only risk, but it's best known risk because it was also published in the media. So we have a slide here where we are talking about those elements that have generated these hallucinations and how they were sanctioned. The key problem here, identified in arbitration, is these sanctions were applied in the USA by state judges. The difference between an arbitrator and a state judge is that the arbitrator doesn't have imperium, so the judge has one and it can apply sanctions to the parties in a manner that an arbitrator cannot do it based only on the arbitration procedure or even the civil code procedure applied in arbitration. Very interesting is also the black box problem. This black box problem does not refer to the hypothesis when we do not know how the AI works. It can be determined how it works and what are the algorithms and what information is being used. However, the problem of the black box is that rather reported to the situation when an arbitrator could use AI without disclose it to the parties and to substitute its own judgment on this case with an AI instrument that could review and draft its award. So according to the law, arbitration law, and New York Convention, an award which is adopted or a decision adopted by AI or which is providing arguments, rationale through AI, it is not a motivated one. So such a decision, such an award, according to Article 5 of the New York Convention, cannot be accepted or validated. I will refer to confidentiality and privilege. What's important here to know is that none of the public tools, AI tools, ChatGPT, Plot, and Gemini, does not ensure what we, the French and Americans say, a privilege. The fact that you are using a platform, so the information that you feed to this platform is losing its nature of privileged information, which can be used by any user, and it can be used by the platform as well, in order to train future models of the same AI. Surely, we talk also about the inequality of arms. Why? Because usually in arbitration, you will always have a party which is a stronger one, represented by a very competent team of lawyers, a team of lawyers which is probably already using AI for research, drafting, etc. While in most cases, especially when we talk about investment arbitration, we talk about the less developed, underdeveloped countries, states, which do not have the necessary competences to use AI. So, from a perspective of the inequality of arms and the right to defense, if this aspect is not regulated, then one of these parties will, from the get-go, be disadvantaged. Another aspect refers to algorithmic bias, as it is called, the lack of independence. And when we talk about the lack of independence, you have to take into consideration the fact that any type of AI module is trained. When you train it, you give it some information which has an intrinsic judgment. And the more they are impartial and biased, the result of the AI will be as biased as the information you feed it. So this is also an element that I consider very important. And the last word, enforceability, that I already have mentioned, this could also represent an important element. In 2025, 𝗬𝗏𝗏 Legal has added this idea of digital stranger. You will find this online, and it refers to the differences, not the differences. It refers to the stranger, or that you know or you do not know, usually it's known, that is involved in an arbitration which should be confidential. So a humanoid may be based on the knowledge that it had previously. Why is this? Maybe take into consideration the different parties and their input in order to lead to a solution. And we see that some of these solutions are being turned into writs of execution, and you have a law that you would like to apply to avoid forced execution, but arbitration leads to a resolution solution that both parties agree upon in order to avoid the coercive force of the state and to apply this forced execution. But the digital stranger, this is an unknown element which could substitute the judgment of this arbitrator. So what we see here as risks and what are the recommendations affiliated. So when we talk about public AI tools, ChatGPT and the others, so we do not have a contractual relationship between the one feeding the information into the platform and the one receiving it and analyzing it. There is no privilege-based report, and we actually recently, as of 17 February 2026, there is a decision published by a judge from the USA. We are talking about a case, in a criminal case, when the questions addressed to AI by the accused were sent. So the questions and the answers were submitted, sent to a lawyer, and the discussion that was raised is, are these covered by privilege? If this communication was then submitted to the lawyer, no, and the judge decided that no, this is not covered, this is not protected by the privilege, the right to. So the benefit of privilege is lost. So on such public platforms, we are feeding the correspondence of your client, the personal data of your client, data on financial elements. So all of these elements could be used against your client by another party. The recommendation is to never feed this platform, to never upload such documents on a public platform. So we have a disclaimer as well, or at least one of these platforms has a disclaimer, namely that the information that you are feeding on this platform are not protected by the confidentiality clause. So on the other side, we also have the larger companies like Freshfield has invested 10 million until 10 million euro until 2025 to create an integrated AI platform to be used for the analysis of documents, or there are systems which are created for the use of legal experts, practitioners, and based on contract or contract-based, it can ensure higher confidentiality, giving also the right to the persons to delete the information once it was used, or to delete the documents once the analysis was provided. So the recommendation is always, when you talk about AI and when you use it in arbitration, to sign contracts, detailed contracts, to foresee these aspects. So never forget that liability is always on the side of the professional using AI, and it is not on the platform on which we are uploading this information. So who sets the rules? We have three major systems entered into force. So first of all, is the first module, institutional rules. So the advantage of including them in under institutional rules, it's very obvious: predictability, consistency, and obligation for parties. In Romania, 609 of the Code of Civil Procedure, if you have decided to go with an arbitration institution, then the rules of that institution will be applied. Similar provisions are, I am sure, that are in the Moldovan Civil Procedure Code, and although the provisions of the arbitration laws in the more civilized countries are also providing for this aspect. Yes, I have only a few more slides left. So the limitations of this system are the following. The technological progress is much quicker than the review process of arbitration procedures. 𝗧𝗵𝗶𝗿𝗍, which is the Vienna Arbitration Center, also the Silicon Arbitration Center has another memo on how to use AI. International Institute of Arbitrators has a guideline, and of course, if you allow it, you will receive it as a link from the organizers. My recommendation is to go through them, not because it's mandatory, but, and the third module is, if the first one, it's a top-down, the second one is a bottom-up, or the third one is a bottom-up based on the party autonomy, and they could use as they wish AI. It is not a recommended model because, as mentioned earlier, and as Mr. Arbitrator mentioned, so when the parties are already engaged in a dispute, it's very difficult to find a common ground, and all the risks mentioned previously could turn real. And the model that I recommend is the one where the arbitrators voluntarily or upon the initiative or request of the parties to address this issue with the first term order issued. So the conference for the administration of the case to address during the first meeting of arbitration, to address the use of AI. And this middle line, this golden line, is the one towards which most of the arbitration community is heading to. And now about disclosure. So when should we disclose that you have used AI to draft certain materials? So first of all, you have to disclose if AI has drafted factual or narrative arguments in your memo, which means that each participant should do it. Also, disclosing of AI should occur each time when we talk about any type of quantitative analysis generated by AI based on a large volume of documents submitted to the platform, and each time when the credibility of a witness, you know, that the declarations of the witnesses could be also uploaded on the platform, and the outcome is it a credible or not witness based on how contradictory are the statements from their own declaration, or corroborated with other type of information. So the recommendation is always to disclose this. However, AI was used only to filter number of documents in investment arbitration, and in those arbitration cases where the rules of disclosing documents are applied, usually in USA this is applied and not in the European case law, where disclosure does not extend so broadly. So when documents are requested from the relevant party, then a list and opus is submitted, and in that pile of document, you have to identify the document that you need. They have to disclose everything that you request. Of course, if there is a decision of the tribunal in that regard, but they have the obligation to disclose even what's any disadvantage to them. However, when this happens, then the document that has one page is buried under hundreds of other pages because the human effort is major and the risk of not finding it is also major. So if AI was used to identify it from an opus, so then it's debatable if it's a mandatory to disclose the use of AI, of course, and take into consideration the aspects that were mentioned at the beginning of my presentation concerning the use of grammar or the verification of email. Of course, then it is not mandatory, it is not required. Of course, there will be cases like in 2024, 2025, the lawyers who used AI were sanctioned, or the courts from the USA have sanctioned the parties in those arbitration cases. And you will see that from the beginning of the year until the end of the year, firstly, applying a fine of $3,000 for the use of hallucination is very different the case law in USA, because for us It's not a source of law. For them, it's a source of law. So for them, the referral or referring to a previous decision, then yes, it's a very different case law approach. So the judge arbitrator could ignore such decisions concerning the other arbitration cases solved according to the civil code procedure. So you see, at the beginning of the year we had a fine of $3,000, but you will see in 𝗵𝗿𝗁𝗍 case, the case was dismissed. There were fines paid, and there were bar referrals related to those lawyers that have used AI, and this was applied in 8 other cases which used similar hallucinations in their defense, and the latest one is as of 17th February 2026. So what are the practical recommendations? And it's my promise to you that this will be the final slide. So for the tribunal, so always include an AI in the first procedural order. Distinguish between low risk, medium risk, and high risk AI elements in order to be able to apply different types of sanctions. Always verify independently any type of reference from any type of material that is presented, because AI is here to stay, and an arbitrator cannot allow himself to use elements which are not correct or which are fake. Take into consideration identifying an independent expert, AI expert, where we use different tools, proprietary tools, and it's relevant, and always take into consideration the attitude of the party that has used elements which you believe to be fake or not real. For the counsel, for lawyers, so never use or never submit AI-generated content without disclosing that AI was used. Also use only those platforms which allow you to maintain confidentiality and privilege. Always disclose any type of elements that have essential elements, important elements on the case that is ongoing, and always make sure that you trace, you keep the trace, and you track what you did in order to be able to show, so keep a record in order to show what was used in terms of AI. And for the parties, my recommendation is that when you are drafting, and when you are still in the pink period, the romantic period, the romantic phase of the commercial relation, that's the time to negotiate all these aspects. So the International Institute of Arbitration has a form of contract already proposed, suggested to those who want to use AI. So in the first procedural order, you have to introduce it for your own protection and agree to use it, and try to limit as much as possible the use of AI in order to be taken into consideration later on, and for arbitrator to be able to sanction the party that will use or is incorrectly using these tools.
Ar trebui să înțelegem că inteligența artificială nu înlocuiește și nu ar trebui să permitem să înlocuiască niciodată un.
We have to understand that the artificial intelligence cannot replace human judgment. And we have to understand what we can do in order to use AI in order to enhance our judgment. And criteria should be responsibility and final check. Key takeaways. Artificial intelligence is here to stay.
Important pentru noi este să învățăm cum să o controlăm.
For us, it's important to learn how to control it,
Elementele referitoare la
to
inteligența
include
artificială, să înțelegem că orice
contracts
informație
elements
pe care
regarding
o
AI, to
lansăm pe o
understand that any information that we upload on a public platform
și împotriva noastră.
can be used against us. And
într-un final că
finally, to understand that arbitrators, if they use AI to write the text of a decision, renounce on their mandate that was entrusted by the parties. Thank you very much. Thank you, Sorina. This topic is very interesting. I have written down all of your practical advices, and I will take them into account. Also, it's good to know that use of AI can be punished if it is not used prudently, and it also involves some major legal risks. So if you have a question, we can take it, and after that we'll have a lunch break, and we kindly invite you for the third panel because it's about the practical side of commercial arbitration that's important for lawyers of each company. Are there any questions? If not, so now it's 1:11. Oh, so there is a question.
Thank you. I am very sorry, I do not speak Romanian, so my question is going to be in English. I am representing German Arbitration Institute and German legal system, and I found your presentation very, very inspiring. I have a question which comes from German legal system, and as German Arbitration Institute last year, to our great surprise, we found ourselves communicating with not humans, but with large language models. Last year, we have established an increased number of statements of claims that were generated not by humans, but by artificial intelligence. These developments are also confirmed by state court judges in civil proceedings and even in criminal law proceedings, saying that the number of submissions of applications has drastically increased because the access to justice has become more affordable for the parties, become easier. It's so easy to generate a statement of claim just using Gemini or using ChatGPT. With a couple of clicks, you can have a reasoned statement of claim. So as I said, we, as the German arbitration institution, we observe this development. The state court judges confirm these tendencies. Can you say that would be the case also for Romanian or for Moldavian legal systems? Thank you.
My purpose here was to draw the attention on the risks of such behavior and to draw the attention that artificial intelligence is here to stay, and probably it's more used than we know that it is used because of the lack of a generalized system to verify what it is AI generated and what it is not AI generated. This is why you cannot, in absence of such a system, you cannot assess a percentage of the cases that are AI generated, but the duty rests with the judge and with the arbitrator to verify each piece of information that was provided by the parties. And this is why I think that the procedural order number 1 in an arbitration is the one that should oblige the parties to act in a certain manner and to disclose. I mean, disclosure, I think, in absence of other tools, is the essential element that should be taken into account. And this is why I think that the parties have a responsibility. All the actors involved have a responsibility. You cannot say that only the arbitrator has a responsibility and the lawyer didn't. You cannot say that the parties don't have their own responsibility. Each of the actors involved has the responsibility to control the way that AI is used in these litigations. And just several months ago, it was enacted a virtual arbitrator. So it is already here, a virtual arbitrator. And several years ago, someone from LALIV discussed about artificial intelligence litigation solving mechanisms. Because in terms of, I don't know, small claims, you can picture a process whereby you monitor the potential answers to potential questions in relation to, I don't know, let's say a consumer issue. And there is a process design by many companies, retail companies, that you have to provide certain information, answer certain questions, and then the end of the process, you have a decision already issued by a non-human saying, yes, you're right, and you're not. If you're challenging that decision, then you go to a human to verify the information and the case file. But most of the process is done by a non-human. I don't think that's possible or desirable in an arbitration. I think that while artificial intelligence is here to stay, and in case of large volume of data, it is usable and it's a benefit for the case, the judgment has to rest with the arbitrator, who has to investigate, assess, judge, and draft reasoning for a particular decision that they take. I'm sorry to keep you from your lunch.
Da, mersi. Încheiem aici, da? Mersi foarte mult și vă rog...
Thank you very much. So let's start the lunch break.
Dragi colegi, bună ziua! Probabil putem începe cel de-al treilea panel, care este
Dear colleagues, I think we can start the third panel that is focused on business and practical aspects of it. We're very glad to see you here present for the third panel. We're glad to see quite many participants. It is my honor to present the speakers. Antonina Netzer, she is a senior counsel at the German Arbitration Institution.
And we are happy to have you here. I will make a short introduction to each of panelists and then we'll start with you. O să fac o mică introducere la toți vorbitorii.
I will make a brief presentation and after that we'll start the panel discussions. The second speaker is 𝗧𝗵𝗶𝗿𝗀, experienced lawyer and head of the legal department 𝗕𝗶𝘀𝗇𝗏 Chisinau. Grigorie, welcome. The next speaker, Marin Chiecu, legal manager, Orange Moldova, and lawyer of the Chisinau, member of Chisinau Bar, and Elena Garaz, my colleague, lawyer, arbitrator, member of Chisinau Bar. I am pleased to introduce our speakers. I would like to use this opportunity one more time to thank you for being here, be present. I'd like to thank organizers for this event, which is a great opportunity to exchange experience. I want to tell you that last year, during the second edition of this conference, during the discussions, someone mentioned that we need a new law, a good law. So you can see that 1 year has passed and now we have a draft law in place, which shows that this conference indeed produces results. Thank you very much. Now I'd like to give the floor to Antonina.
Does it work? Yeah, yes. Thank you very much for having me. Today, I am very honored to be here for the second time in Moldova and to represent the German Arbitration Institute, die Deutsche Institution für Schiedsgerichtsbarkeit, the DIS. The first time I was here, it was 9 years ago, 2017, and I surprised the audience with the fact, as 𝗏𝗏𝗏𝗏𝗏 has mentioned, that German state court judges sometimes have no idea of how certain types of disputes are being resolved because they never get to see those disputes. Those disputes include M&As, V&Is, they include especially maritime transportation or plant engineering, especially if it's a cross-border plant engineering. And state court judges complain that they have to visit the DIS conferences in order to find out how those disputes are being resolved, in order to have an idea what kinds of disputes arise, for example, as a result of post-closure. So today, I have a couple of further revelations for you out of our practice, of the German Arbitration Institute. Dale Carnegie once said that the only way to get the best out of a dispute is to avoid it altogether. However, we know that the disputes are unavoidable. they are routinely elements of business lives. We do know that disputes, business conflicts, they threaten, they disrupt normal business operations. And the longer the dispute lasts, the more it costs. And we know that contentious disputes might even endanger the very existence of companies, especially of small and medium-sized companies. And only those companies that manage to address those disputes at an early stage and in the most constructive manner happen to be the most successful and more resilient on the market. They say that arbitration is the best method for resolution of business disputes. Arbitration is being praised for its flexibility and for its ability to accommodate the end user's needs. However, we all know, well, at least those involved in arbitration, that in recent years, critic appears that says that arbitral proceedings are getting exceedingly long and are getting extremely expensive, unaffordable for companies. So the International Arbitration Survey conducted 2025 last year by White and Case in cooperation with Queen Mary University has tried to identify what factors do actually contribute to dissatisfaction of users with arbitration. And this International Arbitration Survey has established 5 top factors, which were named by the end users as the major drawbacks of arbitration, as the factors that contribute to arbitral proceedings being too long and too expensive. So these top factors were: first, adversarial approach by counsel; second, over-lawyering of the proceedings; third, lack of active case management on the part of the arbitrators; third, excessive procedural formalities; and fifth, excessively delayed awards. These results are basically confirmed by the feedback the DIS gets from its users' council. It's a special organization which was created in Germany for an exchange of opinions between businesses and the service providers in the area of dispute resolution. It unites representatives of all areas of business, of small companies, medium companies, and large German corporations. And this is basically the feedback the DIS has received from the users. And we try to implement into our arbitration rules measures which would increase efficiency of arbitral proceedings. For the sake of time today, I am only going to concentrate on 3 major measures that we consider to be the most important ones in our rules. First and foremost, these arbitration rules impose an obligation on the arbitrators at every stage of the proceedings to promote settlement of the dispute. It's the duty of an arbitral tribunal at every stage of the proceedings, unless one party disagrees, to bring the parties to an amicable settlement of the dispute. Are there any common law trained lawyers in the audience? Common law? Please brace yourself. 60% of all our cases end up in settlement. 60%, more than half of our cases end up in a settlement. This is a number which is unheard of at other arbitration institutions, and we consider this being our greatest achievements. It has its roots in German legal system. In German civil process, judges routinely encourage parties to settle, to resolve their dispute amicably. So it's not an issue for the DIS to have this provision being implemented into our rules. We know that common law arbitrators are feeling very uncomfortable with this duty because they fear being challenged on a biased basis. But unless the party disagrees, there is a duty in these arbitration rules imposed on arbitral tribunals to bring the parties to settle. The second measure we have implemented into our arbitration rules is the conduct of case management conference. Such conferences are conducted as a rule within 21 days upon constitution of the arbitral tribunal. What are those? These are conferences which are organized either virtually or physically, where arbitrators come together with the external parties' representatives, with parties' counsel, and the parties themselves. There is a duty on the part of the parties to be present at such case management conferences, meaning that the management of the parties is present, the CEOs, SFOs, STOs, they all have to be present at those case management conferences together with their lawyers and the arbitrators to discuss the procedural framework of arbitration. In addition to that, the disarbitration rules prescribe the mandatory agenda for such case management conferences, meaning that the arbitral tribunal has to lay down a binding procedural timetable, and they have to discuss with the parties measures listed in Annex 3 to the disarbitration rules, which are designed to increase procedural efficiency. Annex 3 of the disarbitration rules contains a toolbox that has to be discussed between the arbitrators and the parties at the case management conference. It includes such measures as, for example, limiting the number and the lengths of written submissions of the parties. This is a common practice in other countries as well. For example, before the United States Supreme Court, there is a possibility that the court reduces the number or the lengths of written submissions. The same applies to the European Court of Justice. So we have adopted this practice as well. Then the arbitral tribunal might discuss with the parties whether document production shall take place and whether there should be limitations on a non-burdened parties. Then the arbitral tribunal discusses with the parties the use of information technology, the use of artificial intelligence. The arbitral tribunals have to discuss with the parties whether there is going to be only one oral hearing, including taking of evidence, whether the arbitral proceedings has to be divided into several phases, meaning whether, also including whether there shall be partial awards, so on and so forth. So this case management conferences with a mandatory agenda, this is the second measure that we have implemented into our arbitration rules. As a result of such case management conference, the arbitral tribunals draft their first procedural orders, which are very akin to the terms of reference before the ICC. The third measure I wanted to mention today is the fact that the arbitral tribunals have to provide the parties with their preliminary non-binding assessment of the case. This is also a common trait of German legal system. And common law lawyers, you should be very surprised, well, I know you are. This is something that shall never be applied in common law systems, but as I said, it's deeply rooted in German legal tradition. State court judges, as well as German law-trained arbitrators, do provide their non-binding preliminary assessment of the case, both of facts and of law. How it works. The arbitrators meet together with the parties and their counsel, but not for the arbitrators to hear the parties, but rather for the parties to hear the arbitrators, what the arbitrators have to say about the case, based on the written record already submitted. So there are several purposes for this non-binding preliminary assessments that the arbitral tribunals share with the parties. First and foremost, it forces the arbitrators to be of a full command of the case from the very, very beginning. Second, it forces the parties to front load their case, meaning that the parties have to submit written documents, written evidence from the very beginning of the case without withholding the evidence or further submissions till the oral hearing, without surprising the parties at the end of the proceedings with new arguments or with new evidence. Third, such preliminary assessments made by arbitral tribunals help the parties better understand where they are in their case, better understand, assess their prospects of success and their risks. When arbitral tribunals share their preliminary assessments, the parties may better understand the crucial issues crucial for the arbitral tribunals making their decision at the end. Such preliminary assessments usually go hand in hand with arbitral tribunals making suggestions on how the parties might settle the case. And even if the parties do not settle the case as a result of preliminary assessments by arbitral tribunals, they still have a chance to focus on the most significant issues, well, on those issues identified by arbitral tribunals as being most significant for the dispute resolution. And thus, by focusing on these issues, the parties might better present their evidence, might prepare their better arguments on these particular issues. Such preliminary assessments by arbitral tribunals usually look like a decision tree. The practicing arbitrators know what I'm talking about. For example, if there is a question on jurisdiction of the arbitral tribunal, then such a decision tree would look as follows. For example, was there an arbitration agreement concluded between the parties? Yes, no, yes. Whether this arbitration agreement was pathological? Yes, no, yes. Whether the pathologists of an arbitration agreement were remedied by the subsequent conduct of the parties? Yes, no, no. Does it render an arbitration agreement invalid? Yes, no. So these preliminary assessments of the arbitrators take form of a decision tree. And by sharing these views, the arbitral tribunals help the parties to present their arguments better, to concentrate on the issues that really matter. Common law lawyers, as I have mentioned a couple of times, they would never do that. Because of their fear of being challenged on a biased basis or out of fear for endangering the enforceability of arbitral awards. But for Germans, for German legal tradition, it's no issue. Once the parties agree, there shall be a preliminary assessment of the case made by arbitral tribunal at quite an early stage. So basically, these are three major measures that the DIS has implemented into its arbitration rules that are directed at promoting, at streamlining arbitral proceedings, at making them business friendlier, at making them quicker and more cost efficient. And I would be more than happy to answer your questions. Thank you.
Thank you very much, Antonida. Thanks for sharing for your experience. And now I'll switch to Romanian. Dragi colegi, dacă aveți întrebări...
Dear colleagues, do you have any questions concerning how processes were streamlined in Germany? Maybe you didn't hear, but over 60% of the cases resolved through arbitration procedures. If you have any questions, please ask them by scanning the QR code in front of you. While waiting the questions, let's maybe move forward to the next speaker, and that is Ghigore. So my subject is business perspective on arbitration, from drafting the clause to enforcement. I will actually talk from a double perspective as a counsel involved in such cases, but also as as part of the legal personnel of a group, commercial group, 𝗕𝗏𝗏𝗏𝗏, one of the major glass packaging producers from Central and Eastern Europe. So for the business sector, arbitration does not represent simply an academic exercise, but rather risk management. And I would like to emphasize that. So when we are talking about arbitration in the Republic of Moldova and arbitration institutions, it does not mean, well, it is important for these institutions to have the same ample approach as other renowned arbitration institutions and the MPCA have. For the business sector, what's important are the following key elements. So they are looking for predictability, functionality, and to be executed. And all of these elements have to function perfectly for the investors and for the business community to be willing to get involved in a potential arbitration by implementing an arbitration agreement in a contract. What the business sector is expecting from arbitration. From my experience, my own experience working with the business sector, these are called, or I name them, 4 pillars: credibility, control, clarity, and efficiency. So credibility, I believe, represents a key element due to the fact that from the perspective of the business sector, credibility is earned hard, but it's lost very fast. Hence, any independence of arbitration should be not only a real independence from the business perspective, but also to be visible, so reputational, because even if it's only a hint at an issue with the independence, this would already make the business sector to look elsewhere. I'll give you an example from my experience. I told you that I'm part of the legal department of a group of companies, and basically in all the procurement contracts, sales contracts signed, especially with the foreign clients, we maintain the arbitration clause. So our goal is always to promote the arbitration institutions from the Republic of Moldova, because for the business sector, it does not count how prestigious the institution is, but rather how credible, how that potential decision can be executed, implemented at the same time. And we do know that any contract, any convention, the arbitration clause can be negotiated. So in our practice, we are oftentimes confronted with some reservations when they are confronted with a regional arbitration institution. I refer here to the Republic of Moldova, and the explanation is quite simple, because for the business environment, choosing the arbitration institution and the location of the arbitration institution represents an entire legal ecosystem, because we all know that once a arbitration award is issued and the arbitration award is challenged, then it will depend on the location of the arbitration. So for the business environment, it's important to receive a clear credibility message, which states that not only the institution, arbitration institution, but also the legal system is to be trusted. Another element is clarity. So the benefit of arbitration is that it provides clarity. And from the perspective of a financial director, a CFO, so they won't ask you what the competence principle is, but he will ask 3 simple questions: how much, how long, and how foreseeable is this process. So if from a proportionality perspective, cost benefit, surely then this arbitration clause will be included. I want to give you an example. So in some of the arbitration exercises that I was involved, so ad hoc, the clarity was expressed through how well regulated was the entire process. So at a similar level of the institutional arbitration. So initially, it is what is signed are the terms of appointment, and in very in-depth detail are indicated, and arbitrators are unbiased, so the fees are indicated as well for the business sector. This is very important to be able to calculate, and from their perspective, an operational planification has to take place. The procedures, the schedule are also included, and when the written memos will be submitted. So what it's meant is the clarity. And this encourages, incentivizes the business sector to get involved in arbitration. Another element is the control. When we talk about control, we talk about the fact that the parties in an arbitration, they hold the control over certain strategic moments, choosing the arbitrators, choosing the law that will govern that process, choosing the location, choosing the language, and maybe even adapting the rules to certain specific particularities of the industry, depending on the scope of the dispute. The fourth, last but not least important, is the relevance. So when I say relevance, I mean that for the business sector arbitration, this is not an act of principle, but it represents an analysis of proportionality. And first of all, the business sector will verify or will accept the arbitration if a potential arbitral award will be useful and potentially it will be executed, and the costs that will imply will not lead to a historical cost without producing any value for the business. So I would like to give you an example from my own experience. Participating in an arbitration in the maritime law, and I have defended a defendant in that case. So I wanted to mention that the value of the dispute of $120,000, but in that case representing the defendant, the first defense pathway was to defend an objection concerning the jurisdiction competency of the tribunal. I was aware at the moment that it could be rejected by the arbitrator and that the case could then further go to court on merits. So what it happened is that the plaintiffs has analyzed the case and acknowledged that the maximum could be a bit more than 50% of the sum requested initially. Also took into consideration the expenses that were incurred by the potential arbitration, being only the initial face, and also the risk for that award not to be executed because the client was from the Republic of Moldova. And I have also highlighted that it might be also a problem of the rule of law, because we considered some key issues that arbitrator didn't have the competences to examine. So the outcome was a simple one. So the plaintiff has simply abandoned the process. Why? Because the stake was too high and the risks were too high compared to the cost-benefit analysis. So it's not about the principle when we talk about the business sector, but it's about the incurred expenses for that company, the time that the management of that company would have to allocate, while time which could have been redirected to another activity benefiting the company. Another moment that I would like to talk about is the execution of the arbitral awards, foreign ones, versus compared to the formal procedures from the Republic of Moldova. Why I want to talk about this? Because it's part of an entire process of convincing an investor to accept arbitration and to enter contracts where the arbitral clause provides, well, when, for example, one of the partners comes from the Republic of Moldova. Namely, I would like to mention a procedural issue that we have, and a question was raised earlier today concerning the apostille of the arbitral awards, if this requirement will continue to stay in force. So, Article 145, point number 1 from the Civil Code Procedures foresees expressly that an external, a foreign arbitral award has to be apostilled in order to be executed in the Republic of Moldova, which is a nonsense in itself, because we all know that the arbitral awards are not official acts. They are not issued by public authorities, but are issued by private entities. So this leads to a bottleneck due to this formalities. So I guess that when it was included in the procedure of the Civil Code, they did not take into consideration the 1958 Article 8 New York Convention, which foresees that for an arbitral award to be recognized, when it is submitted, it has to be authenticated in the appropriate manner. From the perspective of the Convention, this authentication means that it has to be certified by the arbitration institution, and this suffices in order to be considered valid. The New York Convention did not have the intent to make the process more difficult and to lead to complications the execution phase. In the execution phase. And none of the signatories of that convention cannot add more complicated conditions in order to execute an arbitral award from abroad compared to the national framework. So that's why we have this blockage, this bottleneck. Yes, many counsels, many lawyers find in practice alternative ways to overcome this, but it depends on the jurisdictions. Some are requesting copy of that award, and then they do a notary certification, and then they submit the request of apostille. But in the Republic of Moldova, this wouldn't be even possible, because the Ministry of Justice does refuse to provide the apostille for a copy, although was validated by a notary. So the conclusion is that the business sector awaits a comprehensive view or vision over the arbitration process, starting with the clause, procedure, award, and execution. So a real dialogue between the arbitration institutions, public institutions, and the courts. And third, predictability, how long it lasts, how much it costs, and if it can be, and how it can be executed. Thank you very much. Thank you very much, Grigore. You have referred to costs often in your presentation, and I have to mention that in the Republic of Moldova, the law of the state tax was modified, amended, and there is a ceiling added. There was not a big difference between the arbitration fees and the state tax. So this is a great benefit because it allows either to go for one or the other, because I believe that arbitration stands quite well in the Republic of Moldova, and as moving forward, I believe that it will become better. There is a big difference between what we had 3 years ago and what we have today, and we have the trust of the business sector in using the arbitration clause. More and more it is being closed. The fact that it's not applied as often means that it's also our mission of the professionals to disseminate this information. And let's see what Marin think. I know that you, Marin Chicu, want to share something very important with us, and we are ready to listen to you. In the meantime, please share your questions. Please post them, and we will ask the questions at the end of the panel. Thank you. Good day, and thank you very much, Victor. Thank you to the organizers. Thank you. I'm honored. Yes, this slide indeed. So I would like to together look at this from the perspective of a dispute, and those involved in a business ideally don't want to start war. They would like for peace to reign and to make money. And from that perspective, arbitration can be seen as an instrument which helps you anticipate a potential war, to prepare the battlefield, and to have at least neutral rules, or which would be favorable to us. And I have imagined it. That's why, as Napoleon, as a general that looks into the future and is looking at this battlefield. But in real life, things might turn different, because the choice made by you, so a clause, an arbitration clause, an appropriate arbitration clause can protect your business, can make it more efficient, speed in avoiding some bottlenecks, some blockages, and also speed in executing an arbitral award. But at the same time, a less inspired choice can lead to more pain, costs, and damage. Based on my counsel experience, so there were cases, clients, which tried to return their debt from Moldovan companies, and in the arbitration clause there were indicated inexistent institutions. The place of the arbitration was also not indicated, and this is a real problem. And it is, as it was mentioned, regarding negotiations, so we can still solve something during negotiations, but when you already have initiated the arbitration, then it's very difficult to so. So when we talk about the costs, I So my first two cases, arbitration cases, were at ICC Paris, and I represented a client, a large Moldovan company, and the company believed that they looked very cool, that it's great to have this clause and ICC as an arbitration institution, but in reality, also because the counterpart was not cooperating, was not covering their costs, and in the end has terminated its activity, then the total costs were over $150,000. There were 3 arbitrators, and the Moldovan company has to cover them, and in the end they were unable to recover their debt nor the arbitration fees. Because I represent Orange company, I want to talk a bit about the use of arbitration in the practice at Orange. At the level of the group, arbitration is used in commercial transactions, in very complex transactions, and Orange, together with Deutsche Telekom, has buying a joint venture. So they are working on network elements, and their practice is to use the arbitration clause in all their contracts with the providers. In the birth certificate, from the beginning, in the contract between the founders in the status of Voxtel back in 98, there was a clause, arbitration clause, so all the disputes could be solved through arbitration, and this clause has continued. And in the commercial contracts with local and international providers, so in all the contracts where confidentiality is important, in some cases even with the clients, some have jurisdictional immunity, and in various projects there was a question concerning the contract signed with the state. From my own experience, in some cases, the state institutions accept, even if they have framework contracts or model contracts, they might accept an arbitration clause to protect the investors, and it is useful also in different procedures for important complex processes where some investors could either block or make the processes harder. So these are a few practical lessons and some recommendations. The most important part is that the arbitration agreement is an important one. It shouldn't be neglected. So it's not one that inherited willy-nilly, that you take over from other contracts. You have to adapt it. You have to analyze it. You have to carefully look into it. So I would comparing with an agreement that it's well adapted to the contract, to the situation, to the partner, to the transaction, and it could be compared to a very well developed insurance. So I would also dare to say that in our practice, Orange uses often reconciliation or conciliation, so different amicable settlement procedures or mechanisms, and together, if you combine it with the arbitration agreement, you have to make clear that you are separated, that you are separating these steps, that they are separated when the settlement and then the arbitration starts, in order to avoid lack of clarity. And I've added a few recommendations here. There's a based on the fact that oftentimes foreign providers or contracting parties, foreign partners, they avoid So they wish for, even if they agree to the arbitration, but they would like to choose then a neutral arbitration from another country, not in the Republic of Moldova. And here are some recommendations, common sense recommendations related to that. It's important, the reputations, overall reputation. It's important to choose an arbitration institution that has experience, proven experience, which will improve the quality of the arbitral awards. And of course, the lack of bias, independence is very important. Also, the geographical criteria are important, where the contract is executed, and the proximity to the subject matter of the dispute. And in the context of the Ukraine war, at least in the recent practice, the providers from that country easily accept for an eventual dispute to be assessed in the Moldovan jurisdiction. So it is not necessary for a dispute between two European parties to go to New York, because the costs part is very important. Institutions have calculators, so if that client would have simulated the costs, probably he wouldn't have decided to choose ICC Paris for his case. So some arbitration institutions have rules, and arbitrators also specialized, and also the quality increases for the specificities. And the last subject that I would like to mention, indeed, the entire ecosystem is very important. So I've heard during the first panel that soon we will have a law based on the UNCITRAL model, and Moldova is a signatory. It has ratified the New York Convention, but it is important for a judicial support to be in place and for it to be predictable, for the consistent implementation of the law by the courts in case of the annulment and enforcement of arbitral awards. Thank you very much, Marin. Your presentation was very interesting. And I have a question, if you'll allow it, while waiting for the questions from the room. So I'm very curious. You said that you are focusing on settlement or conciliation. So you are using the clauses, but you are still focusing on settlements. Yes, we do have hundreds of arbitral clauses, but disputes, fortunately, are less, and many of these are being solved at the conciliation phase, settlement phase, as mentioned in the birth certificate. This arbitral clause was already in place, and this has helped avoiding some disputes. The minority shareholder has helped to the amicable settlement resolution. Yes, thank you very much. More or less, I understood. Yes, Yes, I said that I will have more questions. So I wanted to see, okay, it's very clear on the conciliation. So it's about the efficiency from the perspective of the time resources and financial resources. At the same time, you have mentioned that in the case of Ukraine, they agree for the arbitration to take place in the Republic of Moldova. But pay attention, we have a new modern legislation. I believe that it's a very good one. I was a member of the working group, and we really worked very hard on it. So we have very good taxes. So the fees are very good, sorry. So what kind of steps should be followed by the Republic of Moldova, and what should be taken into consideration in order to become an attractive location for arbitration in Europe?
I would like, well, I could envisage a situation when a Romanian and a Ukrainian company could choose Moldova as a good place for arbitration. But a German company with a French one, I don't think so, but I don't know, who knows? Well, I participated as an arbitrator on a case in Moldova. So compared with the ICC case, I believe that we still have room for improvement. Of course, as a institutional experience, processes, preparation of arbitrators, so there is room to improve. But that's a normal thing. They have had arbitration for many years in place, whereas for Moldova, arbitration is younger, maybe is a teenager, or maybe an adult already. No, it's still an adolescent. Thank you very much for your insights and for sharing this precious information with us. If you have questions, please do not hesitate to use the QR code. I have a question considering the topic that I will address further. You've mentioned that in the arbitration clause were included in some contracts concluded with the state. Can you tell us more about those contracts? Because the law on public procurement, no, well, I said with the state, it was with an authority. So it was a contract not with Orange, but another client. It was a contract with a foreign company that wanted to become a resident in an industrial park. And the contract was concluded with the administration of that park. They hesitated because the model contract stipulated the courts of the Republic of Moldova, but as a compromise, they reached the conclusion that to collect the fees that have to be paid by the resident, it was a good idea to choose courts. So I understood it's not a public procurement contract. No, it's something different. So Eliana is making a nice transition to her topic. So using this opportunity, I would like to give the floor to Elena Garaz. Yes, hello to everyone. Considering what was discussed today, it is clear that the businesses are become more aware of the advantages of arbitration, and our goal is to persuade the state to enter arbitration, but in our country, the legislator is still reluctant, and I will present the reasons why. I would like to speak about public-private contracts concluded by public institutions, authorities, and another party. This category is quite broad. It could include administrative contracts where public authorities act as a representative of public power, but actually I will focus on the contracts where the state is a client. So these are procurement contracts, which so when we speak about public procurement contracts, we refer to concessions, public-private partnerships, because they have similar legal regimes. Is it possible to make this image bigger? Okay. So, in public procurement contracts, there are two stages: contract awarding and contract performance. So I would like to focus on the performance or execution of the contract. The award procedure is clear. The state organizes a tender to identify a competition to identify the supplier, either through tender or direct negotiations. So in most of the countries, this is an issue of public interest and is settled exclusively by court. It can be either common law or administrative law courts. Each country has different regulations in place regarding contract performance. Most of the countries, except for Moldova and a few other countries, allows arbitration. So, I would like to address the public procurement contracts because it has they have a big share and a big potential for disputes. The government is buying services, works, and goods. So when we speak about services, this is transport, IT, construction, and many others. The state, the government procures goods, so it depends on the offer of the businesses. At least in the Republic of Moldova, the state cannot perform internally most of the services or produce goods. That's why it needs public procurements. I would like to give you some statistics. In 2025, in 1 quarter only, public procurement contracts that were concluded exceeded 10,000 contracts, totaling 4.5 billion lei. So I believe that it's important to say how possible or potential disputes might be settled. So arbitration provides a series of advantages. First of all, neutrality. Practice shows that courts are more inclined towards public authorities, and arbitration could eliminate this risk, could eliminate elements of corruption or influence badly, because arbitrators have the interest to display professionalism, to build a reputation in order to be invited for other arbitration cases. Another advantage is the technical expertise provided by arbitrators in a series of disputes in areas such as construction, which can be very complex with broad and specific documents. Arbitrators can understand deeper the specific elements of a certain area. The most recent case I had is an international transport contract, and it is very difficult to speak in front of a judge about some commercial customs, about the obligation of the transporters to submit the thermodiagram. And the judge asks, but what law, what regulation stipulates this obligation? So I believe that an arbitrator wouldn't have asked such a question. Another advantage is the ability to handle large and complex cases, to process them electronically, not to ask for a translation. Things that create difficulties in common law courts. And also, I would like to highlight benefits for the state. First of all, the litigation period in case of public procurement contracts. So if this duration is decreased, the state will win. For example, if the state loses the case, then it will have to pay less damages. The procurement market is more attractive to investors, in particular in the context of EU accession. Investors do contract-related risk management, and in addition to other clauses, they also analyze ways to get out of a contract, to terminate a contract, or to settle disputes. So arbitration is a common practice in EU countries, and this is a requirement of investors, because for them time is important and they do not have time to spend in courts. It also reduces pressure on the court system and many other advantages. Contract implementation is the competence of common law courts. We have the law on public procurement, law on concession, public-private partnerships, and it stipulates that disputes deriving from nullity, contract termination shall be examined by courts. It does not clarify what kind of court. Should it be a common law court or administrative law court? So the practice is non-uniform. Most of the dispute would end up in common law courts, but there are some exceptions. For example, a decision which seems very interesting to me, from December last year, a court ruled to terminate an arbitral award on the issues of passport inserts. I don't see colleagues that dealt with this case, so the Court of Appeals terminated the arbitral award. It reached the conclusion that this case cannot be subject to arbitration because it involves public procurement, and it did not differentiate between award procedure and contract implementation procedure, and ruled that the case should have been tried by administrative court, administrative law court. So the law says that this is the scope of courts. Now we are in the presence of some legislative amendments in the context of the pre-accession procedure, in the context of legislative harmonization. A new law on public procurement was adopted. It will enter into force on January the 1st, 2027. It is harmonized with the EU directive on public procurement. It regulates mainly the award procedure and focuses to a lesser extent to contract implementation. The law does not stipulate any challenge mechanisms. Another law stipulates the remedies and such laws, for example, in Romania exist for 10 years already, and they are harmonized with the EU law. So the new law on ways to challenge stipulates that the litigations or disputes related to sectorial public procurement or concession contracts shall be solved by the competent court in administrative law procedure. So this law ends any possibility to have these cases sent to arbitration. In addition to the positive effect is that we will not have this question, which type of court, common law or administrative law, but it does not give any chance for arbitration. unlike the European practices. Considering that this legislation should be harmonized with the EU directives, I would like to highlight that the EU directives do not prescribe a certain way of settling disputes. They stipulate some safeguards, but do not mandate a specific dispute resolution method. Member states retain procedural freedom. So each state has approved their own policies. There are some states that have decided to regulate expressly which cases can be sent to arbitration, such as Romania. There are countries that allowed cases to be subject to arbitration because it is not prohibited by law. And there are countries where arbitration is not allowed, such as the Republic of Moldova. Why? I believe that such cases can be settled through arbitration in Moldova. First, because the law on arbitration left a door open. Law 23 and 24 refer to patrimonial disputes. Let me find the exact wording, just a second. So the law on arbitration, international arbitration, regarding the relationships deriving from international contracts, patrimonial disputes, and the new draft law opens this door even broader and states that legal entities of public law, including the state and the territorial administrative authorities, can conclude agreements on litigation. So the door is open, but the draft laws that I referred to, the first one was passed in the first reading, and perhaps soon will be passed in the second reading, do not allow these cases to be settled through arbitration. Why do we have this reluctance? Perhaps lawmakers, well, I've analyzed the explanation briefs for draft laws, the legal opinions, and I've reached the conclusion that businesses were quite passive, and perhaps if businesses do not insist on this, the state will not come up with the initiative on its own. And I have a feeling that they decided to give this to be the scope of courts because they acted by inertia and because of lack of dialogue. There is still time. Maybe some changes can be made in the second reading, or amendments could be made later. So the question is whether we could include these types of cases in cases that can be settled by arbitration, because that would be for the benefit of both parties, both the state and businesses. Thank you, Elena. I have a positive comment. We in the Republic of Moldova managed to amend the law on public procurements in the very moment in line with the EU directive, exactly in the moment when EU decided to amend its directive. So EU wants to remove the threshold for public procurements by the minimum price, and many other changes. So we'll have more amendments as well. So I think what you have mentioned is a very good idea, and we could discuss it. Thank you very much.
Mulțumesc frumos pentru
Thank you.
intervenție și pentru informație.
Thank you for the information. I would like to say that this saga with the public procurement contracts is indeed an issue in Romania as well. Since 1994, the lawmaker has balanced. Initially, we had a law that stipulated clearly that contract award is the exclusive competence of administrative courts, and the contract implementation is an issue of equality in contract implementation between the authority and the person that won or entity that won the tender. And this is the realm of common law right. And as long as a civil court can settle a contract implementation dispute, it means that parties have the freedom to choose whether to stay in front of this court or to go to arbitration. Then we had a period when all of the administrative contracts, irrespective of whether they refer to contract award or contract implementation, had to be settled by the administrative court. And then we had a lot of discussions what should happen to the contracts that were already in the proceedings. And in the last amendment of 2022, even more strange provision was introduced that was subsequently corrected by the Supreme Court. So the Article 52(1) of Law 101 that has already a bad reputation said the following: in relation to the implementation of public procurement contracts, to the extent in which the claimant is the authority, the competence is the civil law court. But if the claimant is the contractor, then the competence belongs to the administrative court. And this amendment, incoherent amendment, stayed in force until the High Court pronounced its opinion on a case where it clarified that we speak about contract implementation, and contract implementation can be settled by arbitration as well. Also, we have a provision which says that patrimonial cases can be settled through arbitration. So I believe that the formulation that you have in the new law, if it was doubled by such a provision, would be helpful for you as well, meaning that the contract implementation could be tried by or would be settled by arbitration. But in what law this amendment was made? Law 101 on remedies. So the bad reputation, Article 52 or 53(1), it had two paragraphs. The first one was the situation when the authority was a claimant to be settled by the civil court, and if the business or supplier was the claimant, then it was the administrative law court. The only explanation has historic roots. Always the particular cases should be protected by administrative court because it does not have an equal relationship with the authority. But here we have this mental issue that you have mentioned as well, that courts tend to favor authorities rather than private business because the authorities are managing public money.
For you, I have a question, because I don't think it is only in relation to the. First of all, thank you for your kind explanation. Professor Stephen Kroll last year at the Bucharest Arbitration Days already touched upon the subject, and we are looking forward for this panel this year in 4th and 5th of June 2026 about the possibility of the German arbitrators acting under this to provide clarity to the parties in relation to the potential solution. I think that we have the same reservation irrespective of the way that we are educated, common law or civil law practitioners. The lack of independence or partiality in taking a view over the case, it is the same. I think it's playing the same role under the civil law or the common law. So my question to you is whether you had any cases where parties acting under this, not German parties, because I think that there it is a matter of education. German parties are educated that the arbitrators have the possibility, and the judges as well, have the possibility to address certain issues and to provide an insight on how they are considering the case. But have you had any experience with foreign parties that are disputing under this to invoke the lack of independence of the arbitrators if they have provided such insights?
Thank you for your question. I will be more than happy to answer it. But I think there was another question in the audience addressed to Elena, when I understood it correctly.
We can address it afterwards because it was raised already.
Okay. Thank you very much. It's a very interesting question. It was actually considered by the DS while drafting these arbitration rules. We know that some parties have concerns, or some arbitrators have concerns with sharing their preliminary without bias, without prejudice basis views of the case. Therefore, according to these arbitration rules, the arbitral tribunals are allowed to share their non-binding preliminary assessment of the case once both parties have agreed to that. So we do need an agreement of the parties. And once the parties have agreed, afterwards, they cannot raise any complaints. They would be stopped from raising any complaints of having arbitral tribunals share their preliminary opinions. So that's a very interesting point. And yes, we do have in practice cases where international parties, meaning non-German parties, object to arbitral tribunals sharing their views. For Germans, it's a non-issue because they are used to this system of early dispute resolution. And one more thing, it's only natural, it's human to form an opinion. Once you hear an argument or read a written submission, you do have an opinion, you do form an opinion. And the fact that you do not share it doesn't mean that you don't have it. So, but because we hear these concerns from parties coming from Canada, from the United States, from UK, we do have this provision that provided that both parties explicitly agree, the arbitrators shall share their preliminary assessment. Thank you.
Mai avem o întrebare? Te rog frumos, Serghei.
Da, o să am o întrebare înainte de aceasta, dacă îmi permiți un comentariu.
I have a question, but before that, I would like to make a comment with regards to what Antonina has mentioned.
And I would even go a bit further, and I would say that when we talk about impartiality and independence in international arbitration, but especially impartiality, I don't know why everyone's expectation is that, you really should act impartial until you sign the award. But in reality, and it's the way you put it, I don't believe that's how things work or should work. Because once the parties submitted their evidence, maybe before the hearings, but once they submitted their evidence as an arbitrator, I already start forming an opinion. Now, the question is, can I share it with the parties or not? And apparently DIS is saying, yes, you can if there's an agreement. But I think I would like to see a movement towards, you know what, I can carefully share it even if there is no agreement, and then the parties can judge about that. I wouldn't venture to do it now, But I believe there is place for the community, entire community, to move into that direction, because impartiality doesn't have to stay with me. It doesn't mean absolute impartiality until I sign the award. I can start having opinions once the parties put their submissions and submit the evidence. So that's just a comment. Elena, la întrebarea cu soluționarea...
Elena, regarding your question with dispute settlement, the state secretary has mentioned that the article from the draft law that refers to whether a case can be settled by arbitration or not is structured in a way that all disputes can go to arbitration except the ones that are expressly mentioned as excluded. But if these articles do not exclude the public procurement disputes at the implementation stage, it means that they are automatically subject to arbitration.
If the special law does not foresee something different, if the special law will not be modified. In arbitration or procurement? What law do you refer to? Procurement. The procurement law has priority face to the arbitration law. So the arbitration law has special procedural norms. So the procurement law is even more special than the arbitration. So it's more special than special. Under public consultations, I really encourage you to actively participate. Actually, there is a paragraph in the new law which, no, actually, no, it was in the previous law. So regardless, based on the fact that the procurement law is a special law which regulates the sector, this type of legal relations, then I believe that it's not under debate for the arbitration law to prevail. Mr. 𝗧𝗵𝗶𝗿𝗍, you have the microphone behind you. Yes, I went through the norm, I read it, but I wanted to ask Elena, why do you think that norm does not allow arbitration, as long as it says that disputes will be examined by the court in contentious procedure? And maybe you know this, and in administrative procedure, maybe you remember, 𝗓𝗍, when we were talking about the insurance law, and it says that all the disputes are being examined by the court, by the relevant court, and the CPC article, which says that the parties can start arbitration, and it says that if it's not arbitrable, then it could be transmitted to arbitration. Well, I am interpreting this that the court as being those state institutions. So yes, we had this like broader discussion. Yes, and I'm also using the judicial practice in this case, the case that I referred to earlier with the passport forms, where the court has ordered the dissolution because the stating that the tribunal was not competent because the procurement law forbids arbitration in those cases. Yes, but a new problem arises, because it means that in principle that in any special law which states that the disputes under the incidence of this law shall be examined by the court, which means that they cannot be sent to arbitration, which is not correct. All of them, yes. We are negating then the law, yes, but this is a generic term which would include all the arbitration and institutions and courts. I believe that the fact that the litigation, the disputes, it says administrative procedure in that law, which it means that we cannot apply the simplified procedure ordinance, but not that you cannot send it to arbitration. I believe that there is no interdiction, and I am curious if you have in Romania any experience like that. In Romania, it says that the parties can convene on or agree on arbitration, so it leaves room for more interpretations. Well, if we've reached this formulation only because of the jurisprudence of the courts that were refusing to accept your justification, the one you just gave, and based on several amendments in the law, several laws, 101, 109, etc., about the public procurements, because we were not happy with having one single law, like Law 64. And we said, let's have more laws, and that means things are getting worse, because they all should be codified in one single location to be simple enough for those reading them only once to understand them. But because they were oscillating like this, we had periods of times when in Romania we have Article 548 from the Civil Code concerning arbitration, although Elena mentioned that this is competences of the court, but the Civil Code procedure in our country and in yours states that the competency needs to be mandated, identified. But if we talk if that's an exclusive one or not, then we go to a special legislation provision. For example, in our case, an administrative procedure, so it was materially a special or a different type of court. So let's leave the public procurement, but for example, the company litigations of the name of the corporation or corporate, those cannot be sent to arbitration in our country either, but this is an exclusive one foreseen by a special legislation. So my opinion is, so the text that I've seen from Elena, I agree with you, that the text does not clarify that it would be an exclusive competency. By contrary, the first and the second thesis, they mentioned that it is an exclusive administrative procedure and administrative litigation when the contract is awarded, but all the other parts seems to be a competence of, as it says there, common law courts. But you should know that in our Law 101, they separate, or they used to make a distinction, and debates are still ongoing concerning the annulment, right? We're talking about the validity of the public procurement contract, independent of the disputes that were mentioned there, and the execution. And even those related to execution, someone was poorly inspired not to verify with the Legislative Council the coherence between the two paragraphs of the same article, and we were put into a situation when the judge had to decide if it is the competency, the material competency of a civil court or of administrative court. So you cannot have the same contract, for one has the jurisdiction of an administrative litigation and the other one conventionally to go to civil court. Let's say that that is the case. What will then they examine? A part of the contract under one court and on the other is a disjunction. So, of course, it was because it was, yes, a convenient situation because they stayed with the civil code procedures. So until someone said it has to stop now, because the parts of one contract should be able to go to any court or any institution, but to stay together when they are being examined. But in our country as well, we had a situation that part of the literature of the doctrine believing that we should go only to administrative procedures, and then they added a new provision when they said that with the procurement, public procurements, we have to go only to civil procedure because. But what do you do when the parties have already started the execution of the contract? Issues arise, and one of them says that we are invoking the exception of annulment of the contract. So, the contract being void. So where do I go then? To administrative courts, to the civil courts? I don't know. Yes, probably the null merit. These are linked to the infringement of the public procurement procedure and could be indeed an administrative procedure. Yes, this is related to consentment, but indeed it's very little relevant to business. Yes. So if we talk about capacity, so nullity should be assessed through the capacity of consent and capacity. So if it does not meet the minimum legal ground, so yes, but arbitration could deal easily with these strictly civil code issues. Yes, I believe that everything could go to arbitration, but we don't necessarily need this legal provision for that. Yes, so I would like to invite you to continue our dialogue, because I believe that the business sector should build on their debates with the public authorities and continue, because if we don't ask this from the state will not do it for us. Yes, it functions and it works very well when the professional associations participate in that and their representatives are here in the room. So I was informed that we went over time a bit. So if you don't have any further questions, then I would like to thank you for your presence, for being so active and such a wonderful conference. So now I would like to end this panel. Thank you.